Good morning, Your Honor. Your Honor, John Goldpaw, P. 30758 on behalf of Mr. Hul.
All right, Mr. Hul, your name for the record, please. You're muted.
Oh, I'm sorry. Nelson Hul.
Okay, thank you. And thank you for addressing it appropriately, at least from the shots up that we can see. So, two things. One, your client is here for sentencing and his plea to an amended charge of disorderly conduct. I don't see Kevin Hamilton or Jamie Tackett here. However, the court can still proceed in this manner.
That is correct, Your Honor.
And there's also the request, we'll just handle this on the record as well, regarding use of marijuana while on bond. And counsel, as to the sentencing.
As to sentencing, Your Honor, you indicated use of marijuana while on bond. I'm not aware of that.
Well, so Mr. Hul had submitted proof of a medical marijuana.
Oh, that's correct, Your Honor.
And he had one prior to the arraignment that expired, so then he renewed it during the arraignment or during bond phase. And so my thought was that we would chat about that today.
Oh, okay. I saw that in the, but I wasn't present originally. Fine, Your Honor. We've had an opportunity to review the pre-sentence report in this particular matter. Your Honor, this has been an ongoing matter. It's been a lengthy negotiations. This matter actually occurred back in September of 24. I reviewed the video of the arrest. I filed a request for the video of the incident, and we were informed that the actual video of his time at the McDonald's was no longer in existence. We discussed his involvement in this matter and the reasons why this occurred. As to the general background information, as you can see, Mr. Hul has not had an easy life. Some of it is of his own doing, some of it is because of the early stages that he went through, ended up with the being, excuse me, and I apologize, Your Honor. He's been diagnosed with behavioral problems, clinical depression. His parents never married, and he became a ward of the state at age 7. I'm sure the state did as best they could. However, as the court is well aware, that's not the best of all circumstances. He did complete high school. However, he did not graduate, and he received his GED. He also indicated that, and here, that he has a paralegal certification. Trust me, my discussions with Mr. Hul, he's clearly learned a great deal during his paralegal training. He's indicated his health is decent. He's on parole, has been for approximately 3 years. His parole officer is aware of all that is going on in his life. I did not speak with the parole officer, but I did carry on some other conversations with Mr. Hul regarding that. To be honest with you, Your Honor, and I know he wishes to make a statement, but as you can see from his statement, he was at McDonald's. He was there to pick up some food. That's why he was in the area. Things got out of hand, he felt that he was being mistreated. I guess one thing leads to another, and when you review the body cam, it's clear that when the officers arrive, he is attempting to tell them what really happened in there, asking, hey, I need my witnesses, and they're just saying, well, no, and they're just responding and making an arrest, whether, rightfully or not, but he was, and you can see that what occurred and what triggered the incident in McDonald's, and I'm not saying he's not taking responsibility, but in his mind at that time, regarding whose fault it was or whose fault it wasn't, and as you can see from his statement, the long story short is I was in the wrong and I fled this. I think, Your Honor, that this all carried over. And so I know the recommendation is for incarceration. He's had 3 children. He has a 4th on the way. I believe she's pregnant. I know she's pregnant and she's due in about a month and a half. He is not employed at this point in time, though he is still going out and looking. As again, one of the things on his parole is, as he told me, for the 3.5 years, he hasn't violated. His probation officer has not found a reason to violate, which is good. And I'm not suggesting. In fact, he's told me that he does not believe that he'll be violated for parole on this one. However, Your Honor, I'm asking that the court place him on probation. He does have another matter that's in the Lansing Circuit Court. His parole officer is also aware of that. And as he's indicated to me, that's set for hearing, and they're aware of this matter as well. He's on probation not probation, but on bond out there. He's on a tether out there, and he's been in full compliance out there. I don't believe that incarceration at this time would be the appropriate remedy. He is the sole child care support. He's trying to get SSD. That's under appeal. And as he told me, what he's trying to do, Your Honor, is to, he also is attending mental health treatment, and he's trying to get better. He recognizes his past and recognizes that he cannot continue that way, and he's trying to move on. I don't believe that incarceration at this time would be beneficial to anyone.
Well, what would you suggest, counsel? Because the individual in this matter, well, first of all, the way that I would view the facts of this case is that Mr. Houck was dissatisfied with the time it took for him to be served or to pick up a mobile order, whatever it may be. So he decided to then go behind the counter himself to get his food. Then proceeded, when an employee was attempting to prevent him from doing that, proceeded to assault that employee. Now, your client also, in addition to his lengthy criminal history going back to 2008, has a number of assaultive crimes. Currently on probation, on parole, and he's also out on bond on another matter prior to this matter.
That's in Lansing, yes. Yes, sir.
I understand that.
No, I'm just saying.
But for parole to not violate Mr. Houck based upon this incident and this behavior, and for bond violation to not be occurring, I'm not sure if it's occurring actually, I don't know if that occurred, but also for parole violation to not occur on the Lansing matter, I think serious concerns for the safety of the public and individuals in general, given Mr. Houck's tendencies for violent behavior. This was over a mobile order for food that Mr. Houck was tasked by his boss to go pick up. This matter was scheduled for jury trial, and quite frankly, the prosecutor at that time thought that it was in the best interest of justice to offer this matter, or this plea in this matter. And quite frankly, I don't see how I have a choice other than jail for Mr. Houck. Because the purpose of probation is to afford somebody an opportunity to learn from their behavior, fashion conditions to help them modify their behavior. I have zero rehabilitative conditions that I could offer to Mr. Houck. Zero. I have zero confidence that any of the conditions that I would typically put forward for somebody in a matter like this, that any of those conditions would be rehabilitative.
Well,
At all. Mr. Houck, I am flabbergasted that you thought that it was your right to go back behind a counter of a place of business that you are not employed. And then when somebody attempts to stop you, you assault them.
Ma'am, can I speak? Are you asking me as far as opening the floor for me to speak?
Sure.
Okay, well, ma'am, I think you're misinformed on the incident that happened there. And that is why, if the video would have came out, it would have showed the true actions of what happened there, ma'am. And I don't know where you're getting the information of. I was upset about how long it took or anything like that. Ma'am, that is not accurate information at all. There is a police call. There was video evidence. You would have heard all these things if I'd have went to trial, ma'am. But the video was somehow lost. But 14 seconds of another video to show two heads bobbing in was found, which is a mind-blowing to me. And I'm flabbergasted that justice isn't thinking, where is the evidence? Why was not evidence preserved at the time of a crime that you said you seen me commit from a video image? So why was it not preserved? That is the flabbergasted part to me, ma'am, that you are condemning me in your head already off of facts that are not true. There's like no factual basis for what you're saying, besides word of mouth. And anyone can write down their version of the story. Like ma'am, and I know, ma'am, there's three versions of every story, but one version doesn't lie, and that's video evidence, right? And somehow somebody scrubbed the video evidence because they didn't want the truth to come out, ma'am. So,
Sir, pause just a moment. I don't know if anybody scrubbed any evidence or
the video evidence was never produced, ma'am.
Sir, if you'd like to make a statement that the video evidence isn't available or whatnot, you don't know what happened with the video evidence. I don't know what happened with the video evidence. I don't even get the ability to see the video evidence unless it's submitted pursuant to the rules of evidence. And since there was a plea in this matter, that never was an issue.
I would love to go to trial if you
Excuse me. As far as where I'm getting some of that information, some of it's in your own statement, sir, regarding you were ignored for around 5 minutes. So that was in your own written statement.
Ma'am, in my written statement, I confirmed that I stood in line waiting. I stopped a different worker, not even the worker I got into an altercation with, ma'am. I stopped a totally different worker and asked him a simple question of, hey, when does these numbers and I didn't say it with aggression. I didn't say it with irritation. I said, hey, can you please tell me when do these numbers transfer over to these numbers so I can get my order and go? I said, I already paid for the food. It's already done. And before he could even answer, the person who I got into the incident with came rushing over, intervened. What's going on here with an attitude? I didn't get an attitude back. I just explained the same thing to him, man. I showed him the picture I had. I showed him the screenshot I had that confirmed the order was already paid for, confirmed everything was done. I didn't even need to even come talk to nobody for real, man. All I had to do was be handed a bag and go, right? So I didn't go in here looking for an incident, ma'am. I did not. This is not like a
Sir, I
violent
didn't say
home
you
that
went
you're
in
trying
there
to find
looking,
a picture of.
sir, I didn't say you went in there looking for an incident. That's
No, but you
not,
said I'm in there violent prone, ma'am. You're trying to paint a picture in your words. You're trying to paint a picture of this big violent person, ma'am. Do you know how long it's been since I've been accused of a violent crime besides this one? It's been years, years. I have been working on. Yes, I've had a violent past. Yes, I've had a history, ma'am. I was taken from by the state at the age of 7. I was raised in placement homes and lockup facilities. I was never given a chance at true life. I was given the chance at being a caged animal. So then, when you ask me, am I prone to violence? Yes, sometimes I do have what I'm diagnosed with explosive behavior, ma'am, and that's only when pushed. All my violent record I have is assault and batteries. All those are from being locked up facilities, fights in a lockup facility. None of those are from street altercations, being in the real world altercations, ma'am. So I am not violent prone like you think I am. I was in a cage situation with other violent people, and situations became violent. Yes, I chose not to allow myself to be a punching bag to other people. Yes, and because
sir,
I did more damage, I got charged, ma'am. I can't help that.
sir, your matter out of Utah in 2018.
Yeah, 2018. How long ago was that, ma'am? How long ago
Sir,
was that? 18. This is 20. We're going on 26 now, ma'am. That's
sir, we're
years.
in 2020.
That's
Sir,
years.
at the time of this incident, that had been 6 years.
Right.
So
6 years since I had a violent outburst.
excuse me, that was aggravated assault resulting in serious bodily injury. Was
Yes,
that,
ma'am.
were you in custody during that offense?
Was I in custody during that offense?
Yes.
Ma'am, even on that case, there was never no evidence presented. I pled out because I was in prison for 3.5 years fighting the case already. So it just made more sense to go home, right?
Sir,
Take the deal that was offered to me and go home. And that was one of the cases on the deal. Ma'am, I didn't get caught on this crime at the scene. I got caught on, they reported this crime 2 months after this alleged crime happened. Ma'am, you're speaking on something you do not have the facts to, ma'am. You do not have the facts to these things. So you're still once again you're trying to justify in your head why you want to give me incarceration, which is not in the interest of justice to incarcerate me because there are mitigating factors to this case that you are not even taking into consideration, ma'am. You're not. All you have said since you said something to me is about, oh, he's this, he's a menace to society. Ma'am, I did not go, this was not random. I was a working father at work who was denied his food because the color of my skin, and it was noted in the phone call that he made to dispatch. If you'd have heard that phone call when he said it's a black and he threatened my life, come quick. And I never once in fact threatened this man's life. in fact
sir,
in fact, ma'am, I asked him multiple times to take his hands off me before I even touched him, ma'am. Before I touched him, I asked him multiple times to take his hands off me. I informed him he was committing assault by putting his hands on me. Unwanted touching of any person is assault.
okay,
Assault does not have the right to put his hands on me, no matter what you say, right?
Mr. Hub,
Yes, ma'am.
you entered a plea,
Are you justifying that he has the right to put his hands on me, ma'am?
sir.
He has that right? Can you clarify this for me so I have it on record, please?
Listen, that matter is not before the court for this court to make a
Right, but this is what
determination.
you're damning me off of.
Excuse me, excuse me.
Ma'am,
I,
I'm sorry. Give me the time you're gonna give me, ma'am. But I cannot sit here and let you lie on me and condemn me in your head as like this violent individual, and I'm not, ma'am.
stop,
I'm not. I'm trying to change,
stop,
and you're not even
sir,
giving me the opportunity
stop
to change.
interrupting this court. Stop interrupting this court right now. Stop interrupting the court. This court has the information that it was provided after an interview was conducted between one of the probation officers and Mr. Hou. This court also has the criminal history of Mr. Hou and the statements of Mr. Hou, as well as the copies of the police report and statements of individuals at that time. Since there was not a trial in this matter, this court doesn't have any additional evidence that may or may not have been introduced at trial, such as any body cam, any videos that may or may not exist or whatnot. And so this court is basing its ruling in its order for sentence on what it's previously stated on the record. Specifically, the information this court has as far as what occurred in this matter, again, based upon the reports and reviewing the statements of both Mr. Houck and the victim in this matter, and I think there was an additional individual that was named as a victim, but then indicated it was because they were trying to get, they were trying to separate the individuals. This court's not making a determination as to who put their hands on who first. This court hasn't heard any testimony regarding that. All this court's doing is going based on the plea that was put on the record and the facts that this court has before it. Therefore, the court is going to, as I've stated before, the court does not find there's reasonable grounds to depart on MCL 769.5. The court does not find the probation will be beneficial to Mr. Houck. The court also is taking into account that Mr. Houck is currently on parole for a matter, as well as currently out on bond in another matter out of the Lansing Circuit Court, Ingham County Circuit Court. And therefore, the court does not find that there would be any suitable rehabilitative condition for Mr. Houck to participate in probation on. Therefore, this court's going to order $45 days jail, credit for 1 day.
Ma'am, can I ask something real quick, please? As far as the credit timing goes?
You had 1 day credit, sir, for the day you were incarcerated and bond was posted.
Yes, ma'am. Can I just ask you something? If not, it's okay. I keep my mouth shut if not, ma'am.
What's your question regarding your credit for time served, sir?
I also did 14 days in jail on this incident too, but that was through my PO.
That was for what?
That was through my PO. I went and turned myself in after this incident and did 14 days also through my
You say
PO.
PO.
Parole officer?
Yes, sir. Yes, ma'am.
Okay, so that's on that matter. So there's not, I'm not affording any credit for time served on this matter.
All right. It was due to this matter. That's why I was wondering.
I understand that, but that was
I was not-
MPOC, that was as a parole violation, so the court's not.
So that was a parole violation then?
Yeah, I did get violated for this incident and the other incident. I've done 14 days on both of the incidents I caught. In 3 years, I've only gotten in trouble twice, which is an outstanding job for most people on parole.
Okay.
I wasn't aware of
So,
that,
all right, that's, okay. The court's going to do the 1 day credit for time served, and the court's also going to order restitution if requested. As of this point, it does not seem to have been requested, but there may be a request, I'm not
And then if
sure.
he has a right to, we can have a hearing on that. I
Of course.
understand. No, I understand.
All right, as relates to your date to report, sir, the court will give you until Friday to report. So you need to email into Ms. Shine so she can give you the information regarding that report date and how to report and when to
I believe
report.
this is Ms. Short.
I mean, Ms. Shine, did I say short?
No, you did say Shine, but I believe this is Ms. Shaw.
Oh, Ms. Shaw, okay, either one, in the probation. And then also as it relates to your medical marijuana card, you have something in here from a cannabis doctor. It appears, but not from a treating physician. And then the question I had was because it says that you didn't have any, you were not under a doctor's care, you're not taking any medication at this time. Given that this court's not placing you on probation, the court doesn't find a need to continue to address that issue.
Thank you, Ron.
Is that it?
Just make sure you email to Nicole.
Okay.
Good
So
luck.
I'm done now, though.
Fine.
Yes, you're all set.
Okay. What time on Friday? Because my fiance doesn't get off work till like 6 on Friday.
Okay, well, that's why I'm having you email Ms. Shine, email her by 12:45, and she'll communicate all that with you. Okay, sir?
Okay, and then so I'm done, right? Judgment and passed down, right?
That's
Yes,
correct.
and if you want to appeal it, you certainly have the right to appeal it.
Well, at this point, I'd just like to say that your fucking court is a joke, and you are carrying your fucking self.
Sir, you are on
I'm
the
still in
record,
court, so
and this is a court of law, and that's not acceptable.
good luck.
All right, we're on the record in the matter of Dawn Damron, 232-180.
I haven't talked, I just.
Oh, you're not spoken, okay, all right, let's go
Back on.
off the record for a moment. All right, I know that we have the chat council, excuse me, I'm sure.
You want to do it tomorrow, Aaron?
This time.
I'm here tomorrow.
I'm gonna be here. I've spoken to my client, we're just gonna set it for trial.
Well, it is already set for trial.
Well, I
No, but I
mean,
know we were gonna go over that today because,
because that thing was, yeah, but.
yeah, so let's, it should just take a couple minutes, so let's do
Okay.
that. Okay, we're going to
I'll
step
get on
off,
Zoom.
we're gonna take a brief recess, what's that?
I'll get on.
Have you spoken to Arthur, Tuck? Have you spoken to that
I
person?
just gave.
Okay, that's fine. All right. Okay, and so, Mr. Marino, Ms. Dix, I apologize, I had an in-chambers conference with council, on the matter, and so I had to address that. And so, let's go on the record in the matter of LVNV funding for James Marino, 2401048.
Yes,
And council, your appearance for the record, please.
Yes, good afternoon, Your Honor. This is Natasha Dixon on behalf of plaintiff. My B number is 82333.
82333.
Yes, Judge, 82333.
Okay, thank you. And Mr. Marino, your name for the record, please.
James Marino.
Okay, and so we adjourned to today's date because the plaintiff had put forth a proposal for a stipulation to dismiss. And there was some concern that Mr. Marino was not willing to sign it unless there was specific language in there that the plaintiff had already removed the negative impact on Mr. Marino's credit score, correct?
Yes.
Okay, and so we had set this date for today because Ms. Dixon indicated that she had previously advised her clients that they should remove it and was going to speak with them again. However, she indicated as I was checking the two of you in that her clients have not yet done that, nor have they given any indication to her that they are going to do it. And so, Mr. Marino, based upon your statements at the last time you were all in court, is it safe to presume that you're not going to sign the stipulation of dismissal? Or are you comfortable signing it now, knowing what Ms. Dix had stated on the record, and stated when she had checked in this morning?
I'm not comfortable signing it.
Okay, so as I instructed last time, sir, I cannot give you legal advice, and you should really speak to an attorney about that, because Ms. Dixit cannot make somebody remove it from, she can't make anybody do anything, okay?
Correct.
Now, if there was a motion filed before the court could hear arguments, and the court could potentially order something, but Ms. Dixit herself cannot order anything. And it appears as though the balance of what was put forth as far as the resolution, and that the plaintiff is dismissing the matter. It appears all of that is satisfactory to you, sir, except for the part requiring the plaintiff to remove that from your credit report, which, as I just stated, she cannot. She's indicated she's advised them. So I'm not sure you want this matter still pending.
Well, I'd like to request a MSD then. They haven't proved anything of their
That's not
suit.
how that works. Mr. Marino, that's not how that works. So you should have really spoken to an attorney before you came to court today. You can't just orally request a motion for summary disposition. There are court rules that accompany that as to how that has to happen. And there's been numerous times that you all have been here, and this court's determined and agreed that you're not the proper defendant, and so the plaintiff is trying to get a stipulation to dismiss this matter. And one of the conditions, it appears as though that you want within that stipulation is not one that she could put in there.
Okay, so if they're not going to remove it from my credit report, then I don't want to sign anything until they remove it. So I guess the next step would be go to trial. I mean, I'm not too sure. Or do I have to go get an attorney?
I'm not going to use the court's time to set a trial. And even say that doesn't require the plaintiff to remove it from your credit report. What one of your conditions, sir, that you're asking for before you sign it is not something that the plaintiff's attorney is able to do at this point.
Okay. Can the court order the removal of the credit report, the whatever it's called, the negative report?
Well, if there was a motion properly filed before the court could hear arguments, and the court could hear the legal reasoning by both sides as to what this court's authority is as it relates to that, but that's not before the court. What's before the court is the plaintiff's proposed stipulation to dismiss.
Okay, so I would have to get an attorney to file a motion for the MSD, is what you're saying.
Sir, what I'm saying is that I told you last time that if you wanted to do something different other than sign the stipulation to dismiss, then you should contact an attorney. I told you that a few times ago. And so here's where we're at.
Okay, well, I guess I have no choice but to go get one. I have been in contact with one. I will call him after this, and I will have him file the necessary paperwork.
Can you please have Carly put that on the bench, please? She doesn't have this one on the bench. This Marino, LVNV versus Marino. She doesn't have it on the bench.
All right.
And Ms. Dixon, you cannot put a stipulation in the order to dismiss that your clients are going to remove the negative reporting to Mr. Marino's credit report?
Unfortunately, I cannot do that until my client makes that decision. I mean, I can certainly, I have certainly advised them, but until that actually happens, if I put that in, if they don't, then obviously that would not be a true statement, Judge. So,
Okay.
So that's why I'm hesitant to put anything, because it would not be a true statement if they don't.
Okay, and so in the interim though, Mr. Marino, you would have a judgment that if anybody were to, that creditors would be able to see, or lenders would be able to see that something was dismissed, on that. But sir, I'm not sure why you're waiting until now to, have an attorney now, as opposed to when I had indicated, at the last hearing that you should speak with an attorney regarding the requirement, or the stipulation that the credit reporting gets removed.
Okay, so I have to have an attorney right now to do something, is what you're saying?
What I'm saying, sir, is I suggested last time that if you were not in agreement with the stipulation as written, that you should have an attorney. You should speak with an attorney regarding that, as to whether or not what you're even requesting is something that is a valid condition of the stipulated order to dismiss.
Okay, so I have to sign this dismissal thing before they will even remove that report, is what is being said?
I don't know, I don't know what it is you're saying, sir. I'm not understanding what you're saying. It's not on here. That's why I asked you about it.
I don't want to sign that dismissal form without them removing the negative credit report, because I don't trust them. I mean, they waited.
I understand that, but also, I'm not sure how you are expecting them to remove something from a credit report when the matter is still pending.
Okay, so if I sign this dismissal and they don't remove it, then what can be done? If anything can be done? That's where I'm at. They've had 90 days to remove.
Sir, I can't give you legal advice. That is why I suggested that you speak to an attorney about that.
I have, and this is what he said. He said we can do this, this, and that. If not, call him and he will take over and he will do what he needs to do. But I figure I'd come in here and say, hey, if they could put it in writing that they would dismiss it, I'll sign it. I have no problem. That's my only issue that I have, is the negative credit report, because it's doing harm to my financial stability. So if they can,
Sir, I can appreciate that, but I will say this. This is what I'm going to put out there. I'm not advocating for one position or another, but you have a plaintiff that filed this action.
Okay.
And you filed an answer, which is why the plaintiff can't just dismiss on their own, because you've filed an answer. The court, after having extensive settlement hearings and extensive hearings to determine whether or not this is the proper defendant, it was determined that this defendant is not the proper defendant.
Right.
And so the matter is still pending. And so I'm sure that that's impacting your credit still, because it's pending. Right. And the stipulated order to dismiss that's been put forth would cause this matter to be closed. And then there could be post-judgment motions filed by either side. I don't know. But it doesn't appear as though a plaintiff is going to remove something during a pending matter. So those are the challenges that seem to be happening right now. So I feel as though it's the old adage, what comes first, the chicken or the egg?
Correct.
The horse or the egg, right? It's one isn't doing one until this one's done, and this one can't be done until this. So, I mean, where's the resolution? Because I don't have anything before me to order one way or the other
Right,
regarding your credit report.
all right. All right,
So, and then I'm not sure what I'm gonna have you keep coming back for, because the plaintiff wants to dismiss it. And then
correct,
now you're agreeing to dismiss it because they aren't able to meet, or can't, I don't know, meet one of your conditions, which is prolonging the case, which is prolonging the negative impact to your credit report. So I don't know, sir, what more can be done, in this matter.
okay,
Absent having any motions filed, whether they be post-judgment or not, I don't know, but that is why, the last time you were here, which I believe was 2 or 3 weeks ago, I indicated that, you should consult an attorney regarding the feasibility of what you are demanding before you sign the dismissal.
okay. All right, I'll sign it. And then I'll have to wait.
So, let me clarify. I'm not trying to force you to sign it. I'm just putting all of that information on the record so that you make a determination as to what it is you want to do with that information. I'm not forcing you to sign something under duress or otherwise, right? You stated you've spoken to an attorney. I don't know what that attorney told you.
He said, try to get a MSD and that he said that's better than the dismissal without prejudice. So, but you know, I've been dealing with this so long. I'll sign the paper. I just want a guarantee, if possible, that they will remove the negative credit report. That's it. You know, it could be a separate piece of paper. They say, okay, it will be removed by such and such a date if you sign this dismissal, and that's it. I just want a guarantee because of their debt collector. I understand that, they want to dismiss it. They haven't proved it was me. I understand that. I just want, because once I sign it and it gets dismissed, they can wash their hands of it and they can still leave the negative credit report on there, which affects me. So if she can figure out something that, a piece of paper, or tell me something, in a breakout room that, yeah, she will get this done and yes, it will be removed, I'll sign it.
Okay.
Judge,
Counsel? I'm
yes.
sorry. Go ahead.
Yes, Judge, may I add, I unfortunately, I cannot guarantee anything, but I will say this, that even if Mr. Marino signs the stipulation to dismiss without prejudice, and even if he signs it and sends it back to our office, I will continue working with my client regarding the credit report. So it's not something that we'll just say, well, he signed it and I'll just forget about it. I will say that I will continue working with my client and advising them that even though he has signed it, the matter is closed. This is something he has requested because he believes it's not him. So while I cannot make any guarantees, I can tell him that I will continue, I won't just drop the matter regarding the request he has made regarding the credit report, even if he signs the stipulation.
Okay, is that satisfying?
Okay, I'll sign it. I'll sign it and send it to him.
Okay. All right, so let's set this for next Friday as a review, just to make sure that everything's been signed and received, okay?
All right.
Thank you, Judge. Would that be August 22nd?
Yes. And you have that document, correct, Mr. Marino?
Yes, ma'am. I'll sign it and I'll send it to him.
All right. All right, thank you. Have a good day.
Thank you.
Just something. Would that be 11 a.m. as well?
11 a.m. on the 22nd. Just
11
confirm.
a.m. 22nd.
What time?
11 a.m.
Okay.
All right, thank you. Have a good day.
Thank you.
All right, thank you.
want that, John, I just,
What you want?
the court, we're ready on Tuck.
Talk,
On
okay.
Damon Cole, when I walked out, you indicated this was a jail report.
I thought it was.
I,
could be wrong.
and I don't see it in there. I
No,
do,
it's probation violation.
that's all
That's
right,
my fault.
and we're ready on Tuck.
Okay, perfect, okay. All right, let's go on the record in the matter of Arthur Tuck, 2527A. And counsel, your appearance, please.
Your Honor, John Goldthorpe, P. 30758, on behalf of Mr. Tuck.
All right, and Mr. Tuck, your name for the record, please.
Arthur Tuck?
All right, and I do see that you're at work and you stepped away, correct?
Yes.
Okay, I do apologize for your delay today. There's been some technical issues that have occurred, and I do know that you've been here for a bit. So today's the date scheduled for a probation violation. Mr. Tuck is on probation for operating while visibly impaired. He was sentenced April 14th of this year. And it's alleged now that Mr. Tuck has tested positive for alcohol July 14th and failed to pay. Counsel?
Your Honor, again, John Goldthorpe, P. 30758, on behalf of Mr. Tuck. I had an opportunity to review the violation of probation as well as the recommendation. At this point in time, after my discussions with Mr. Tuck, I've also advised him his right to a hearing in this particular matter. He wishes to set this matter up for a hearing. He indicates to me that he has not had any alcohol since the day he was placed on the tether. As to the payment, he has made some payments and is in the process of making other payments, just for the record.
Okay, so are you requesting the lab, the collection?
That's correct, Your Honor.
Which one?
We'll need the collections as well as the lab.
Okay. All right, we'll set that up for, September 3rd.
Thank you, Your Honor.
September 3rd at 11:30 a.m. And the court's going to order a $5,000 personal bond. If you're to test right now, sir, what's in your system?
Would be nothing at all.
All right. We will see you on September 3rd,
Thank you,
What
Your Honor.
time?
11:30.
Okay, thank you so much.
It'll be in person.
That's in
person?
person, sir. I'm sorry, what?
You said it was in person?
Yes.
Okay.
Okay, thank you.
Yep, thank you, bye.
Have a good day. All right, we're on the record for Dawn Cole.
No, I have to speak with him.
Oh, all right,
No,
let's go
I have
on.
to be put back in the breakout.
All right, Mr. Cole? Whoops, he's not gonna do audio. Mr. Cole? Mr. Cole? Mr. Cole, I'm going to put you in the breakout room 1 with Mr. Goldpot. I need you to unmute and turn on your camera.
Okay, I'm sorry, my phone had died.
No, I know, you've been here and then you've had to log back in, I get it, no problem. Just make sure you hit join. Did you hit join? There we go, okay. So I'm gonna handle this one and then, Dave, I can chat with you while we're having Mr. Goldbach, meet with them. Okay, let's go, Mr. Cole's back, where's Mr. Goldbach? All right, Mr. Cole doesn't even have any audio anymore. Where did he go? Oh. Let's just get rid of Zoom altogether.
Yeah.
It's like, it's extra. It's a lot of extra headache, there's extra work with it, there's just,
He's trying to get hold of him right now. He's on.
I think if he yells louder,
Okay, Mr.
Did you guys
Oh,
know dreads?
where's Mr. Cole?
Well, that's me, I don't dread.
I know that's you,
I
but Mr. Cole's not there anymore, so I'm gonna give him a minute
Okay,
to log back in, because when he drops off, he logs back in, so
okay.
we'll give him a quick minute here. Okay, Mr. Cole, can you please, turn on your camera?
Yes, ma'am. I'm trying to right now. I'm so sorry.
And I do apologize, I know that you've been on all morning, and I'm sure that you're having an issue with your device. So what we're gonna do, sir, is, I know that you're speaking to Mr. Goldpaw, and I know that based on, you have low battery, is that what's going on?
Yeah, my phone had died. I had to run to my car. I'm sorry. I was at work and I had to run to my car to charge up my phone.
Yeah, no, that's okay, would you prefer to have another date?
If you can, if we could, what day will it be?
Well, we could do. We could do tomorrow if that works for you, or we could do next Wednesday, the 27th.
Yeah, next one, the 27th would be better.
Okay, let's do that, sir. I'll just enter a plea of not guilty, and we'll just set it for August 27th, okay?
Okay.
Your Honor, that would
Sorry.
be,
That's in person.
In person.
Well, actually, are you working that day?
Yes. I mean,
Okay,
yes, I'm sorry. Yes.
you can zoom in, just basically.
Okay.
That's because of the court's, the delay stay here, okay, we'll let you zoom in. Okay,
Thank you.
you're welcome, all right, we'll see you back in 2 weeks, thank you.
Thank you.
All rise. 14th District Court for County of Washington, State of Michigan, county session. All those having business before the court draw near, the Honorable Judge J. Cedric.
You may be seated. What? No, I plan on being the only sunshine in the. All right. Right, Ann?
Right.
Okay. I look like a forced answer. Aenddale Management LLC versus Francisco Burns.
Good morning, Your Honor. John Ivanchik on behalf of the plaintiff moving party.
All right. And this is your motion for reissuance of the writ?
That is correct, Your Honor. If the court recalls, the defendants have not been in possession of the property since August of last year. The court officer went out, posted the original writ, didn't communicate with us to let us know that he had done that. And then we were unable, there's still possessions in the house that need to be removed and need to be removed properly.
Possessions presumably belonging to the defendant.
Correct, Your Honor. Yes. Yeah. So I do have a writ here. Don't know if I need to go pay for it first. Or...
I think it would, if it's a reissuance of a writ, it's going to have to be an additional.
That's fine. I can go run down and pay for it, and then they can put it in the file. And does the court want me to issue an or provide a written order?
Here, I don't. Actually, I thought you prepared one.
I don't think I did actually when I looked through my file this morning.
Let me. I thought there was one attached, but maybe not. No, that's okay. I don't need an order.
Okay.
The defendant having not appeared, and also based upon the merits, court will reissue the writ, and I'll sign that once it's presented to me.
Thank you. Have a good day.
They're gonna need that probably to process it. Okay.
I'm sorry, I thought you got an hour.
That was my Canadian. Pardon. Arbor Commercial Realty versus Scott, is it Sendeus?
Right, Your Honor. Your Honor, Nicholas Ryan Opaleski, appearing on behalf of Arbor Commercial Realty LLC, standing in for attorney of record Timothy Dabolski.
Your name, sir?
Scott Sendes, Your Honor.
All right. And we are set for trial on the money damages.
We are, Your Honor, although we've been in negotiations. We are asking the court to adjourn this approximately 2 weeks, whatever works best with the court schedule.
Is that a correct statement, sir?
Yes.
All right. And hopefully you guys can come to some resolution on it.
That's the plan.
That's the object, right? Or the thought.
September 2nd.
I can go set, what's my other date after that?
After that is September 6th.
I had the September 2nd or 16th.
The 16th is fine, Your Honor.
Will that work for you, sir?
Yes.
All right. September 16th, 2025, 9 a.m. All right.
Thank you, Your Honor.
No, lie. Court does call the case Hamilton Crossing 1 versus Victoria Bolton.
Good morning, Your Honor. Parissa Gazari appearing for plaintiff.
Victoria Bolton. And how would you like to proceed on this?
Your Honor, this case was adjourned from last week because I think that Ms. Bolton didn't get proper notice of the hearing. My client has been in contact with Ms. Bolton. I believe she did know of the hearing. She is not here. She did file a motion to set aside the judgment. I'd request that that motion be denied. She mentioned to my client that she did have money in escrow.
That she did?
Yeah.
Yes.
And I would request that that be released to plaintiff. We have a judgment. I don't believe we submitted a writ yet. I will, once that money in escrow is released and applied, I will see if Ms. Bolton wants to do a conditional order of dismissal. I also understand that my client received a termination notice from MSHDA stating that it sounds like due to VAWA, she's moving out on the 30th of September. So I'm not sure how that plays.
Gotcha. All right.
It is a large balance.
And just so that you know, there's a total of $840 that's in escrow.
Thank you.
So the motion to set aside the judgment is denied and escrow is released to plaintiff.
Thank you, Your Honor.
Take care. Court does call the case Lakestone Apartments versus Nicole Sandberg.
Good morning, Your Honor. Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Your name?
Nicole Sandberg.
All right. And where are we on this case, folks?
Your Honor, we have come to terms for a consent judgment in this
All right.
matter. With Your Honor's permission, we can provide a copy or we can place those terms on the record.
If you could state them on the record. And then
Certainly, we do find that there is rent to retain possession in the amount of $300, along with other money due of $314.47. That does reflect past due utilities, as well as $20 a month late fees, and court costs of $232 for a total due and owing of $846.47. Box 4A is checked, indicating that payment will be made on or before August 23rd of 2025. Should the defendant fail to do so, money judgment will issue in those same amounts.
all right.
May I also add too that she said she talked to Lakestone and that they would also be willing to do a mold test, because I'm not 100% convinced that there isn't a small leak in our apartment. They did do a little bit of work on that, but I was saying that conditionally on if there are like medium to high levels of mold, then I would like them to like visually actually check and look inside the wall to make sure there's not a leak, because they said there were some signs that there wasn't, but yeah, not 100% convinced.
Your Honor, we would note for the record that we indicated that we would pass along that request to Lakestone. I have not had a chance to speak with my client regarding whether that would confirm that. We would note this is a non-payment of rent case, and that the prior mold test found there were lower levels within the unit than outside by, I think it was like a sixth of the percentage of, I think it was like under 20%.
Somewhere low to medium, but yeah,
Correct.
basically.
But we would just note that for the record, that was not part of this agreement.
All right. So ma'am, just so that I'm clear, you're requesting that they do it, but that's not, this agreement isn't contingent upon them doing it.
Right, I'm still gonna pay that money that I do owe them, but I'm thinking that part of the reason why the cause of the water bill being so high that's been going on, because like I said before in our last case, it's been like double to triple any other place that I've lived, and it's saying our usage is climbing on the graph when it's not, it hasn't been. So I would like them to further investigate that if they're willing to, but yeah, I am gonna pay that outstanding balance of $800 regardless.
I hear you. What I'm trying to get to is if Lakestone, council talks to Lakestone says, no, we're not going to do it. We've done this other test. We're satisfied with where it is. That isn't part of this agreement
Then I would have to file like another case after that or something if I wanted.
Well, you'd have to do whatever you're going to do, but I'm just saying, do you want me to sign this agreement knowing, or at this point, not knowing what Lakestone's answer is?
Yes, yeah.
Yes? Okay. All right.
Okay.
Have any other questions regarding this?
Me?
Yes, ma'am.
No.
All right.
The escrow account that I told you about in our last court date, that should be able to.
I'm sorry?
The amount that they're asking for that's in my escrow account, that should be cleared by the 21st or 22nd. So I'm happy with the 23rd.
All right. Very good. All right. Court is satisfied with it. I will enter that judgment. Okay. Today is what, the 12th?
Yeah.
Still. All right.
Thank you, Your Honor.
Thank you.
Are we free to go after this?
Pardon?
We're free to leave after this?
What you want?
We don't have to stay. For
You
the
want
whole
Ellen to hold you?
thing?
What?
We don't have to wait for the whole session to be over, right? We could leave.
Oh, see ya.
Sorry, it's my first
Go.
time in court, so
All
thank
right,
you.
bye.
Oh, is that possible? Can I get a copy of it?
Yeah, you can stop at the front counter. The
Okay.
file will be up there shortly.
Thank you, Your Honor.
You're welcome. No, nobody's asked if they can leave. They're like usually bolting for the door. Are these? Okay. Arbor 1 West versus Rico McGuire et al.
Alice Friedman for the plaintiff. Alex Henry, I'm back to the defendant.
Okay, where are we going on these cases that are taking up space for me?
I think we're just in limbo here, Your Honor.
Pardon?
I think we're just in limbo here, to be frank. The judges, circuit and federal, have ordered mediation, and that's being scheduled with JAMS. Judge Victoria Roberts is going to be the mediator, and see if we can get things resolved. There's been a little bit of headway. The city's still demanding air quality testing of every unit of the two buildings in question. They still haven't certified them for occupancy, even though they are otherwise ready to go.
These were the two buildings that we were talking about before.
They've been fixed for two months.
Only thing holding these two buildings up are air quality testing and boilerplate covers. Outside of that, there's everything on the CO list, correctional list has been done. Mediation, so we're just fighting over air quality and boilerplate covers. Had 2 evidentiary hearings with Judge Conley on this particular topic so far. Our experts have testified, their experts have testified about reliability of air quality. The idea is that after this hearing, she's going to decide whether or not it's required of us or not. And so the next hearing is set for September 5th, where I believe the final expert from the city, who's from the county department, health department, will provide some information. And then the judge will be able to make a decision, and hopefully we will be able to get these buildings online at that point. They are working on other buildings at the property. Progress is being made. As I know, the air quality issue first appeared before your court. At the last hearing was the first time we actually heard the city say they're only requiring air quality testing in these two buildings, which has never been the position before. It's always been, we want every unit in every building, all the buildings in the world tested. So
Right.
That is a good narrowing. However, the issue still remains, it's unreliable. So we're
Just,
it's not been done. So, but progress is being made at the property. They're working on the other buildings. There are still things being held up in the next set of buildings, requirements, but we're dealing with those.
Like requirements for engineered drawings for drywall repair before a permit will be issued.
At this point, yeah, that's the holdup for the next building.
I didn't misspeak.
They're requiring stamped engineering drawings for every drywall removal. At this point, no matter the size, and so it's blowing up costs.
what? Hey, because I have to ask the question, what's an engineer going to certify out of drywall?
You know, those are the questions we're asking too, Your Honor. We're submitting permits, paying the permits, and they're getting denied because they don't have engineering drawings saying that what's the language, I believe? We don't have engineering drawings that will show that the removal will comply with the code, I believe is what the language said. Yes, we need drawings that need to be stamped. Code needs to be referenced on the drawings, and they need to be able to determine if the work will be able to conform with the provision of the code from the drawings. So that's holding up the process in some of these buildings, and reasons why permits are not being approved. So we make progress in one area and we get kind of setback. So, but they're working the best they can through it. But at a certain point, Arbor One cannot continue to just comply with a reasonable request. So it's holding things up. But yes, the two buildings are ready. And so as soon as we get word from Judge Kunke, we will be able to place folks in these beautiful units. So we've mediation, we hope to be, got dates yesterday, we circulated, we hope to be mediating in the next 3 to 4 weeks.
How long do you think that, I'm not going to hold you to it, I'm just ballparking, like how long that process may take?
I mean, we're gonna schedule for a day, and with the idea that obviously if it's not successful in that one day and we need to carry on for another day, I think the parties would certainly be agreeable to doing what we need to do to get it done. There's a lot of cooks in the kitchen. The caption is 3 pages long at this point, between attorneys and parties. So it's going to be a process getting it all done. But I think everybody's going to go into it in good faith.
Just recently, Legal Services filed a motion to intervene for the Arbor One Tenants Union, which should cover most of the counterclaims that might, be popping up in this case. So once that's been approved, we'll probably be able to, I think, get a lot of the tenants out of this courtroom.
I do find it ironic that the Legal Services of South Central Michigan hasn't had the time or the manpower or womanpower to file appearances in the cases before you, but now want to file an action to intervene in a complicated circuit court and federal court action.
We've opposed the motion, but that's up for hearing.
Yeah.
That's up for hearing actually tomorrow, before Judge Kunke. So we'll likely have a decision there. And
then I think once that decision happens, I'll then figure out what to do with these cases. I mean, I like you guys, but not
that much.
I think at this point, again, while we do oppose the motion, if it was granted, I think that would cover what we're doing here. So I wouldn't see a reason to continue keeping these cases going, but we could definitely advise the court as soon as that comes down, we can let the
Alright.
chambers know, and we can go.
Okay.
The last order you entered from the court, escrow order with regards to the, I believe, $62,000. I reached out to the city to confirm whether or not they received it, whether or not it's been applied, haven't received a response back yet. So, I mean, at this point.
As to whether or not they receive, because we paid it, the way I did it is we paid it directly to the city.
Correct. And so I was just trying to confirm, because we didn't have any notice of that or anything, which is, I'm trying to confirm, did you get it? Has been applied, we're good to go. Just to cover bases, because I know your order said it would go directly to them. I didn't receive a response. So while they could have it, while it could be applied, I'm just alerting the court that I haven't received a response from the city yet on that, so I'm not sure. At this point, with the buildings being held up, it's really.
That is insane. I'm sorry, but it just seems to me there was 60,000 that was paid over specific to particular bills that they were complaining about. And they won't acknowledge that they received it.
I emailed the city attorneys on August 5th, required specifically attaching an order. I think I just forwarded the email from the report with the order saying, hey, I've heard nothing. So
we can. When did we do that?
So according to JIS, the check was cut on the 17th of July. So it would have been mailed out.
On the 17th of July. So can Kerry figure out if that check has been cashed?
Yes, she can, actually.
Because if she can confirm that it was cashed, at least that gives you some information, because they would have had to do something with the money.
right. And obviously once we get the okay to get these buildings online, the money will be applied. It's really not an issue until that happens, but I just wanted to cover bases and kind of take care of everything. So
We also have escrow in other cases. And I'm a bit unclear as to how the parties perceive and what the court should do with those funds. How you perceive those funds. Do we know how much is?
So from the tenants, I have $11,560. From the plaintiffs, I have $9,286.
So I got about 20,000.
20,846.
I'm sorry, can you give me that last number again?
$20,846.
And that was from the plaintiffs. That was funds that I directed them pay to the court when they were receiving it. And then the others is money paid directly from tenants.
I mean, at this point, Your Honor, our position is that the statute says that money should be used for remediation. So we would say that it could be released to Arbor 1, and we could provide the court with accounting as to it being applied to remediation efforts at the property, which is what the statute requires to be done with rent in the instance where there's no COC. So that would be our position. And like I said, we could provide the court with information as to how that's used for the purposes of remediating these buildings.
We take the opposite, of course.
Of course you would.
Injunction, we think that would go back to the tenants. Then there's also the issue where some tenants were relocated to 14B's jurisdiction. They also have escrow there, and there's been an order where if that escrow in this court was to be released, it should be released to 14B for those tenants with those ongoing.
Should be released to where?
To 14B's escrow.
There's been an order to that effect?
Yes.
I don't have that order.
I can provide that was under Judge Washington's order. And I do also think that was under the understanding that due to the preliminary injunction, that escrow would be released back to the tenant. I don't know if that order would still stand if it was released back to the landlord.
This is the first we're learning of an order that the court
escrow.
Yeah, Your Honor, unfortunately, there's a different law firm that's handling cases at Arbor One for the 14B district jurisdiction, so we're kind of dealing with a couple different opposing counsels that.
Yeah, but even if, I don't care who's handling it, it would seem to me that if there's been some directive or request that this court do something, I'm not even sure how that would work. I mean, I don't have a problem if somebody was residing in a 14B unit and paid money here, transferring that money over. I wouldn't have a problem with, and I think I've said that. But that sounds like some generic order that the monies that are here for the tenants are to be turned over to 14B.
I think it was only specifically for tenants who were relocated to units there and were still paying escrow under the assumption that it was a temporary relocation to the 14A district court.
Say that again.
They were relocated to units in 14B. They assumed it was a temporary relocation, so they continued paying escrow to the 14A while their cases were ongoing. And those are the tenants that will be affected by this order.
Okay, that again doesn't make any sense because my understanding is there are provisions in Judge Conkey's order as to what happens with that escrow if they were to leave. Right?
Yeah, and
if they leave Arbor One, there's I can't even recall specifically what it is, but yeah.
If they break their lease and leave, they would get a certain amount of refund, rent paid.
Right.
In September, and then they would also be able to request the release of escrow held by the state
and
if they paid it.
That was sort of an issue because these tenants were relocated prior to that order. So it was unclear if they'd be affected by that order, if they'd be able to request that since they'd already been relocated. And at the time, they weren't sure if they were being relocated permanently or if they'd be allowed to go back to their unit when it was repaired, because it was unclear how soon that would be going on at the time. Obviously, it's gone on quite a while, and now it seems like a permanent move. But
so if these folks were relocated prior to I think a part of the issue here is that we're talking this move out agreement is for people who intend on leaving Arbor One permanently.
Correct.
And then we also have folks that could be relocated if they request and they have intent to return back to Arbor One. And so we've got folks who were relocated before all of the Judge Conkey case, before the order. And so they're kind of in a different position than folks who have requested relocation after the order was entered. Another issue is that we've got folks who have requested relocation after the order was issued, who don't seem to really be interested in temporary relocation, but also don't want to sign leases. So it's really in this kind of weird limbo area. And it's a lot of gray in this order, which is part of the problem. So there's a lot of moving parts here.
And part of our filing with the Arbor One Tenants Union, we did name these 3 tenants specifically to try and address that at the circuit court level and get some clarification on what should be done with them so that we're not bouncing between the 14A and 14B courts for these 3 tenants.
Can you give me the name of the 3 tenants you're referring to?
Yeah, it's Natasha Drake, Edwina Harris Freeman, and Lawrence Grove.
And these tenants are all on the Ypsilanti side right at this point?
Yes, the township side.
Oh, yes, township. Okay.
They have. So, and you're saying they have escrow here?
Yes, because they were all in this courtroom prior to all this.
Yeah, but that doesn't mean that they paid escrow.
Yeah, I know that they do have escrow in here. I checked about a month ago. I don't think it's changed. I don't think they've added anything to it since then.
You got them?
So Ms. Harris Freeman, do you want dollar amounts?
Yeah.
So Ms. Harris Freeman, I see $650. The other one was, you said Lawrence Grove,
Yes.
45. I have $820. And I'm sorry, who was the last one?
That was Natasha Drake.
Ms. Drake has $2,970.
Senator, you're proposing that what's done with that escrow?
Nothing at this time. When it is released, I think it should be, one is, I think all it should be released to tenants, but then for those three, it would be released to 14B instead of the tenants.
And how do you propose or see that happen?
Your Honor, we would help facilitate that if necessary. It can be given to our office that we would then deliver.
Oh, no, that's not going to happen. I'm just saying, why would I do that?
Well, alternatively, Your Honor, if it was simply released to the tenants, then they would be under the order to simply pay it to 14B.
Yeah, but how
about it just gets released to the plaintiff?
Well, the question becomes, the only ones that would go over, in my mind anyway, and it certainly can be changed, but the only funds that would go over to 14B would be those funds that were paid here pursuant to the escrow, but I'm presuming that they paid their rent over at 14, at the unit at 14B.
Well, that therein lies the rub. Many haven't paid their rent, and that's why there are cases at 14B for non-payment of rent. So
right,
that's where that's coming from.
No, I got you, but there were a couple of folks that they got relocated to wherever, and I think it was into the villas. They got relocated. They weren't sure where to pay their escrow. And I just told them, pay it here and we'll straighten it out. That was under the presumption that what really was going to happen is that relocation was temporary and they were coming back to Arbor 1. But now that's not the case. But I don't know first of all, under what authority I would release that escrow to 14B. That's the first thing. I don't know that I don't think 14B can order me to release it.
Yeah, Your Honor, and it is that situation where they were relocated. They thought it was temporary, and there's been varying degrees of payments made to the landlord at the new villas location. Another issue is I think they didn't get leases, so they didn't know what they were supposed to be paying. If it was a new rate or if it was simply the old lease that they'd be paying under between the three tenants.
Right, but this order that's at 14B says for 14A to do what?
Well, I don't believe it's specifically to 14B, but that when those escrow amounts are released, that they be paid into the escrow for Judge Washington's for 14B.
So that if I order it released to plaintiff, that order is saying plaintiff has to pay it to 14B?
I don't think it specified the plaintiff. I think it was done under the understanding that it would be released to the tenants due to the preliminary injunction that was in the circuit court. I don't know if it thought of it being released to the tenants.
Well, just by way of example, so even if it's released to the tenants, that order isn't directing my court to do anything. That order is directing the tenants to do something. Is that right?
That is my understanding.
Okay, then I'm not going to care. I mean, I thought it was something that was telling that I had to, and I love Judge Washington, but I don't know that she can do that. So
I don't think she would try.
I don't think she would either. I mean, I think I would probably get a phone call rather than an order. But okay. So that's something that still has to be figured out as to who.
Yeah, I think.
Seems like it.
And maybe, I'm sorry, I don't mean that. Yeah, I do mean to interrupt you. But part of that through the mediation process could probably deal with this, because even if they're successful in their intervening for the tenants union, these are individual funds.
Right, and just in general, the idea of the mediation, it's gonna be a global mediation. There's a lot of cases happening, so the idea is that this would, to the extent that there's a resolution reached, it's gonna cover the gambit of everything involved. And even if the motion to intervene is denied, our whole opposition is that their interests have been covered by the city and the prosecutor throughout this entire case. Legal Services has been a interested non-party pursuant to Judge Punky's, delegation of that and at every hearing. So there's no shortage of protecting the tenants' interests thus far, even if they're not allowed to intervene. So I don't think that that's going to be something where they're left out to dry here. So
Got it. Okay, just backtracking on one thing second. The check that the court issued was cashed on August 1st.
okay, and like I said, I emailed them on the spin. So okay, well that's confirmation to them for me. So
Yes, so they've cashed it, and I would hope that they've abided by the court's order as to where to apply it.
Thank you, Your Honor.
Only hope and pray. All right, so what I'm gonna do on this then is I'm just gonna put another date into the future. Was that what?
it might make sense, given that the mediation has to.
None of this makes sense, but go ahead.
Agreed. Mediation has to occur by October 22nd.
Got
So I would say maybe a date after that.
Yep.
We'll mediate, we'll advise the court resolution, and then we're possibly done here.
Why don't you give me my first date in November?
Your first date is November 4th.
All right. So why don't I adjourn it out to there? If it looks like things have resolved or something is headed someplace and you need to move it beyond that, just contact Ann. We'll move it out.
Okay. Very well. Thank you, Your Honor.
Thank you. Where'd Stacy Washington?
I don't know. I didn't see her walk out.
She's right there.
Yeah, no, hopefully she's coming back.
She just walked out. Go find her. Come
She's
on,
right
Alan.
It's to reflect anything during.
Court does call Beal Properties versus Jason Mitchell. Oh, there she is. Okay. I thought you had just left me. Let me handle one more thing and then I can. Okay. Okay. All right, Beal Properties versus Jason Mitchell. Counsel.
Good morning, Your Honor. Gabriel Lacy, 79685, plaintiff, Bill Brown.
Joe Lloyd, Your Honor, appearing on behalf of Mr. Mitchell.
All right, where are we on this case, folks?
Your Honor, if I may.
Yes, sir.
Some facts have emerged since we met last. There is now an order from the city that the property is not to be occupied. It's red tagged. It can't be used. And my clients are not interested in trying to get through that. So I think in some ways possession is less of an issue. So there's the possession issue and the money issue. And what I'd like to propose to the court is this. If my clients would consent to an order to move out, given a sort of a reasonable window in which to have liquidation of their property and to get it out. And then they can evaluate the condition of the building so that if they have additional claims to make, they can do so. And then what we would do is submit it to the court on briefs and affidavits. The court could ask for oral arguments, it could ask for testimony, or it could just give us a number. But I think there'd be some judicial economy in that. It would acknowledge the order that the city, the order to not occupy that the city has set down. And
when did that happen?
Your Honor, this is what's on the door. On all
the red tag.
Red tag, yes. And the city has said, your copy is bigger than mine.
Yeah, 8-4.
Yes.
Okay.
If I may, Your Honor.
Sure.
This is a commercial lease. So, Brother Counsel is approaching this as if there is a habitability issue tied to his client's requirement to pay rent. And in a commercial lease, there are independent covenants and the condition of the building. And if my client breached any part of the contract between the defendant or Bill and the defendant, that does not include the defendant from paying his rent. That's well established in Michigan law under commercial leases. And Brother Counsel is making it appear as though because of the condition of the building.
Well, except that, Counsel, you might be right as to what we would commonly know as habitability issues. From reading this red tag, I don't know that that's the sole issue.
His counterclaim, I do believe, should be removed. However,
should be removed.
Should be removed to circuit court based on what he stated in his counterclaim. I don't think this court has jurisdiction to even address Brother Counsel's counterclaim based on what he stated in his counterclaim.
I believe in my counterclaim, I specifically stated that we were seeking no money in it over and above the court's jurisdictional limits. If I didn't, I'll tell it to you right now and I'll amend it. Because we are not seeking to enlarge this right.
He did say that, but he also stated that they had over $30,000 in damages and that they shouldn't have to pay rent. The rent is over $30,000. That in and of itself is over $30,000. And he's asking this court to remove their burden to pay that past due rent. I understand that the building is red tagged right now, but they owe past due rent.
Right, but it's going to be an interesting question. I mean, if it were a residential unit, certainly a certificate of compliance would need to be in place prior to the rental of that unit may delete any obligation to pay rent. What I don't know in this case and can't tell is what was the reason that the city red tagged it. And I think that's going to be a big issue because if, just by way of hypothetical, if they red tagged it because there wasn't water to the premises, I might be more inclined to go along with what Ms. Lacey is saying. And that is that these are sort of independent covenants and they still may have to pay rent because they would have known we're in a commercial lease. If, however, there are significant, let's say, structural issues that have led to the red tagging, where even if it being a commercial lease, it was never fit for whatever use intended because it can't be. Then whatever. What are you holding up that I cannot read from?
A business occupancy certificate from the city of Ypsilanti that the defendant.
When is that from?
Acquired when they signed the lease.
When was that?
This is from September 4th of last year.
Oh, September 4th of 2024?
Yes, Your Honor.
Okay, go ahead.
If I may, Your Honor.
I love the city of Ipsy.
Yeah,
Go ahead.
well, don't we all? But the timing of this, I mean, the court, when we submitted to the court a brief that contained a structural engineer's report that was very specific. And just, if I may, and we also submitted a copy to the city, and promptly after it was submitted to the city, they came out, did an inspection and red tagged the building. So I think the structural engineer's report certainly has some bearing on this. And that has, you know, it's, I think it's in the court file, I think, at this
Your
point.
Honor, I would strongly object to the structural engineer report.
Oh, yeah.
When I reviewed the structural engineer report, he's calling inner walls, outer walls. He's calling structural beams that are not structural beams. It doesn't take someone to have an engineering degree.
Well, how do I know that? How do I know that?
How do we even, well, for one, he needs to bring the structural engineer in.
Well, hold it, no, but what I'm saying, okay, look. A structural engineer comes along and says X, whatever it is. Based upon that, at least as I'm to understand Mr. Lloyd, the city red tags.
Said you love the city of Ypsilanti.
So, but what I'm trying to figure out is, the objections you may have to the engineer's report might be legitimate, but I would presume that the city would have caught that.
Presumption is not.
What?
We need to drag the city in here too. I'm not an engineer, Your Honor.
Oh, joy.
I can see some errors, and we did have.
We're all lawyers. We're the opposite of engineers. We don't play by the exact.
And if I could see the errors, Your Honor, it's not going to take much to ordeer the city and ordeer the engineer. And
You see how Lacey did that? She said, "I'm not an engineer, but if I could see the errors." It was
Your Honor, if I
But
could.
you're claiming, excuse me, just a second, but then you're claiming that this building shouldn't be red tagged.
I'm not claiming that, Your Honor. I am claiming that the defendants entered into a lease. They used the building as it was to be used. They had an open business and have not paid rent. I am here for the past due rent that my client is owed based on the lease that they entered into with my client.
Okay, but I hear you, but what I guess I'm getting at is, what, nobody can tell me, why is the building red tagged?
According to the city, it says that it has, it's found the structure to be unsafe and attached the structural engineer's report, and is requiring a stabilization plan within 30 days. Would you like that? I have a copy.
Well,
I would too. I don't have a.
So,
But
and
it's
what's
based on
the date of that?
August 4th, and it's based on the flawed engineering report. Ooh, and I'm surprised.
Which is why you have to say it's flawed, because you don't like that. I get it.
And Your Honor, we did talk about getting our engineer here. They need about 2 weeks' notice to free up a half a day of engineer's time.
Looks like we need a new date, Your Honor.
Well, but let me circle back to the plan I proposed to the court. We just give them back this place so that they can fix it and do what they want.
Yeah.
Please give us an orderly amount of time to remove our property, and then we can come together and argue about money all we want.
We filed a money judgment, Your Honor, in this case. And we would like.
You don't want
our money
possession?
Judgment. We want possession and our money judgment. That's why both of them are on the same complaint. And his
So,
counterclaim.
so can I ask a question now, Ms. Lacy? What's wrong with their initial proposal regarding clearing out possession of the premises?
Because my client wants to be made whole as far as the past due rent. My client put a lot of money into helping the defendants get their business off the ground and going, and they want to.
That's fine, but what I'm saying is, we really have two issues. We have the issue of possession and we have the money issue, right? So they're saying we'll solve the possession issue and then we can fight about the money.
But the money has nothing to do with their issues. This is a commercial lease.
What do you mean it has nothing to do with their issues?
It has nothing to do with their issues in that they're still obligated to pay their rent.
Okay, but all right, let me ask you this. Well, that's going to be a question as to whether or not they have to pay their rent given the red tag, but that's going to be an issue. But then the question is let's say I say you're right on everything, Ms. Lacy. I've never said that and I doubt I ever will. But let's just say that I did.
Record.
If
Can I have 1 second?
apparently you're about to take it anyway. How many more do we have? Is this the last one? That's it? Then I'm done. Then I can do something happy and talk to Miss Washington.
Your Honor,
Yes.
after talking with my clients, we will agree to the idea from Brother Counsel as long as the defendants do not remove anything that is bolted down.
I don't know what that means.
That means attached to the structure.
I know it. I know.
Your Honor.
When I walked down the hallway, Alan, did I look stupid when I walked in today? Because some days I look that way.
You asked the question, Your Honor.
No, I know what you mean. I'm just saying.
You had it renovated.
So what you're indicating is the fixtures.
Yes, Your Honor.
What's the lease say about the fixtures? Now this is where a commercial lease does become important.
Your Honor, if I might make one point.
Yes.
The lease very specifically makes the landlord responsible for structural defects, deficiencies. And that's in paragraph 13.
Got it.
So the tenant further covenants agrees that he will at his own expense, and I'm reading from paragraph 15, Brother Counsel. During the continuation of this lease, keep the said premises and every part thereof in as good repair. And at the expiration of the term, yield and deliver of the same in like condition as when taken, reasonable use and wear thereof, and damage of the elements, except expected. The tenant shall not make any alterations, additions, or improvements to said premises without the landlord's written consent, and all alterations, additions, or improvements made by either of the parties hereto on the premises, except movable office furniture and trade fixtures put in at the expense of the tenant, shall be the property of the landlord, and shall remain upon and be surrendered with the premises at the termination of this lease without molestation or injury consistent with the foregoing.
Your Honor, we will not remove anything that is not a trade fixture, which they put in, and leave the premises in the condition in which they got it in the first place. So we're not trying to strip the place out. It was pretty bare when they initially rented.
Is that acceptable? All right, then I don't know why you guys needed me.
We need your seal, Your Honor. Talk is cheap. and
Yeah.
Court orders are dear.
So how long will it take them to vacate the premises?
Can we do it in a month?
A month is too long,
Well, it can't be occupied at the moment. I mean,
so it should take them a day.
no. I mean,
It shouldn't be occupied.
Really?
occupied.
Lacey, hold on. Lacey, really?
They've had.
Really? No, Lacey, really? You said that a day? Is that what you said?
2 weeks.
No, is that what you said? Oh, now you're gonna try to be more reasonable in 2 weeks.
2 weeks, yeah.
So if I just sit here and wait, you get more and more reasonable.
No, but.
Oh, yeah, okay. A day. So when is the city supposed to come back to do anything regarding this red tag?
30 days, right?
Well, they're looking for a report in 30 days.
A report from you guys?
Correct. The defendants have denied the city, the water department, and my client access in the past, so we need them out rather quickly so that we can go in and do what needs to be done.
They have rekeyed it, Your Honor.
Pardon?
I think they put a lockbox on the door. We're not denying them access.
Who put a lockbox?
I believe the landlord did.
They were going to,
Oh, they were going to.
but they were able to get access, so they
Oh.
didn't need.
Okay, they were going to put a lockbox on the door, but instead they've gotten access and we're not trying to keep them out. I mean, you know.
Is there a reason you can't be out the first week of September?
That would be 2 weeks. No, today is 12,
That would be about
18 days. Let's see.
about 3 weeks.
I know the auction company needs about 15 days to get everything inventory listed, run the auction, have people pick it up.
So that's why we were asking for 30 days.
Got it. Okay, so you're basically whatever's there, you're gonna auction. And that's how you're basically removing it from the premises.
Correct.
Right.
Got it. Okay. All right. So is there a way that if the city knows they're moving, that you can get the city to give you additional time in which to file your plan?
I'm not sure. Have not looked into that yet.
I know. Because it was a reasonable thought on somebody's part. And so Lacey wouldn't look into that.
Your Honor, they have enough access to be making a plan.
Pardon?
I'm sure they have access now to get in order to make a plan. I mean, we don't want them to interfere with, our liquidation.
Yeah, they've already came through with their engineer.
Yeah, they brought the engineer through. They'll need to bring other engineers through. They might want to bring the city through.
So is that correct, Ms. Lacey?
That is not correct. We have not brought an engineer through.
Okay, but have you brought somebody through
Brought
to
somebody-
try to begin to address the city's issue?
I don't know that it was to address the city's issue, but we did bring somebody through. He was not an engineer. He was a construction.
Right, but I mean, the problem here is you're disagreeing with the structural engineer's report. You've got to submit a report, which is going to likely be attacking the structural engineer's report, but then to whatever extent there may be some defect in there, you're also developing a plan to correct that.
That is correct.
Right?
That is correct.
Okay, so all of that, from at least what I'm hearing, can happen, right? While they're liquidating and moving.
We can do the first week of September. Your Honor.
Okay, that's not my question now, because
It's the question she wanted.
well, they didn't want it
I know.
until it started getting worse, and then they want that. But that's not how it works here. he needs time to liquidate, which if it's going to be by the time they get in inventory 15 days, and then people have to come pick the stuff up. So the 1 month is actually, given that that's how it's occurring, seems to me to be a reasonable period in time. All right. The question then I had is whether or not the landlord can go ahead with what they need to go ahead with and address to the city within that time frame. And it sounds like since access is not an issue, that you can, right?
I will presume that it's possible.
I don't know what that means.
I can't guarantee anything because I don't know what a structural engineer or whomever else my client needs to hire to come in and create the plan. I don't know how much space they need. I don't know if their structures, fixtures, items are in the way for them to do the report accurately. Those are unknowns for me to give you a confirmation on what.
Okay, and maybe you're right. But let's say, and it's not going to happen today, but you're not going to get a judgment today for possession. Okay, so let's just look at this from the realistic standpoint. So let's say my next date was September 2nd. You guys come in, I give you at that point a judgment for possession. You can't do anything until at least September 12th.
Correct.
Which, oddly, just by way of circumstance and the way calendars of the world work, is 30 days from today. What a concept.
What a concept.
It is so hard being this smart. So, if I give him 30 days to get it out, I think you're going to have to do two things. I'm going to give him that reasonable period of time of 30 days to get his stuff out. I just don't think that's unreasonable. But then the plaintiff will be permitted entry to the premises for the purposes of whatever their structural analysis is. But then it's going to be up to the plaintiff if for whatever reason prior to the defendant vacating the premises, if they run into an issue either regarding space, either regarding whatever, it's the plaintiff's obligation to then work with the city and say, I can't do X right now. Now, I don't know what the city's response to that's going to be. I'm just going to have to say that. Bye. See you. Does that make sense? I don't care whether you like it. The question is whether or not that makes sense.
I understand. Yeah.
It does make sense. It's a little bit.
It's a little what?
It's a little undefined, but it does make sense.
Well, that's because all of it can't be defined. I mean, what your client's going into right now is somewhat undefined. Correct. Because you're objecting to their structural analysis, but then you presumably have to do something, but that is not defined to you right now as to what you may have to do, right? So then you will have 30 days to vacate by the 12th. And I think that's the only thing that we'd have to do, right?
Your Honor, from that point, we still have the money claims to deal with.
Oh,
so I would propose that they have a time to amend their pleadings, because if they have an additional money claim, to make it. And then I would like that we submit it to the court on briefs and affidavits, and then provide testimony as you ask for it, rather than show up and have.
Now, he asked for a trial, now he's asking for briefs and affidavits.
Well, in lieu of a trial, yeah, we do that sometimes. And if the court sees factual issues that it needs to have testimony on, it'll tell us. But if there's not a lot of factual questions that they were, I think both parties have claims that in a different world would exceed the court's jurisdictional limit, but both of us are willing to live within the court's jurisdictional limits. And, you know, yeah.
Well, brother counsel speaks for himself.
Okay.
Our claims after.
You want to remove this?
After.
No, if you want to transfer it, I will sign that order.
It just may happen, Your Honor. I have to, he wants briefs and affidavits and he wants me to look at this more thoroughly than just my past rent claims. So I may be requesting a removal, Your Honor.
Well, I was anticipating.
You do that, you do the affidavit, it's automatic. So,
yeah.
I mean, I don't.
Yeah.
We await your pleasure.
So when is that going to happen?
Well, I have to review well, one, it's gonna have, I have to wait until we see what they review. Yeah. Because part of our deal or settlement was gonna be the equipment that we left behind so that my client could market the place as a turnkey operation. However, if they're gonna take everything out, then my client won't be able to do that. So the dollar amount that my client will be asking for may be more. So we can't determine that until after they have vacated.
All right, so here's what I'm going to do. I'm going to adjourn this to September 16, 2025, 9 a.m. I'm going to indicate that the defendant is to vacate the premises by September 12, 2025, and that the money claims will then be addressed going forward.
Right.
And let you guys get whatever you're going to get in order, pleading wise or whatever, and then make your decision as to whether or not you want it removed.
Thank you.
Thank you, Your Honor.
Thank you.
Plenty of time for lunch.
Well. It's like, look what the cat drug in. Miss Landy, go ahead.
Good afternoon, Your Honor. Ashley Landy Feltus for the people. At this time, Your Honor.
Wait, no.
I know.
No. We're not changing names.
Okay.
I've known you since law school.
Wait, now you get to know me with a new name. Say it again. Feltus. All right.
No, we're not doing that.
No, yes, we are, Your Honor.
No, well, hold it. Is it hyphenated?
No.
It's gonna be what?
Feltus. But I'm in the process of changing it with the Bar Association. Landy is the new middle, so it's new name. We're gonna need a proper spelling for the record. I will send it in a chat to Anna. At this time, we move to any.
You are messing with my whole day.
Sorry.
My whole day. I was in a good mood. All of these people expected me to be in a good mood, and now everything that happens is her fault. Go ahead, Miss. Was it Feltus?
Feltus.
Feltis?
TES.
You don't even spell it right. Go ahead.
Yes, Your Honor. This time we waive any conflict in the Honorable Court in the Office of Public Defender. People do not believe that any conflict exists. Make a waiver of the avoidance of all doubt.
Parenting, right? Still?
Yes.
Okay, go ahead.
Same name. Assistant Public Defender Lauren Kearney, the Public Defender's Office, likewise does not believe the conflicts exist, but if one does, we also waive.
The court, for its part, also does not believe that there is a conflict either in the Michigan court rules or the cases decided there. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Dawn Damron.
Ashley Feltus for the people.
Come on, I'm not mad at you.
Your Honor, Assistant Public Defender Lauren Kearney. Your Honor, this is an expungement that although the Public Defender's Office is the attorney of record on the case, we did not file the expungement on behalf of Ms. Damron, however, we did handle the underlying case, so I don't have any information on this file.
All right, very good.
Hello,
Hello, what's your name?
Dawn Damron.
All right. And you're seeking to expunge one conviction of operating while intoxicated, is that correct?
Yes, sir.
And Your Honor, for the record,
Yes.
people, I have done a little bit more research into this. If the court has the information from the Attorney General with the iChat printout, the court may note that there's a 2018 conviction for operating while intoxicated, third offense.
You said that came from the AG?
The information I have set aside with the letter includes the iChat, and I can also report with it as well. I say that to say, and it may be with the original petition. I'm not entirely sure how it comes to the court's file, but I was able to find a June 7th, 2018 conviction for operating while intoxicated, third offense, which then led me to find that complaint, which does indicate that Ms. Damron unfortunately does have 2 prior convictions, a 1997 conviction, as well as this 2007 case that we're here on today. So unfortunately, Your Honor, I do believe that this was not her first OWI offense.
Right.
And I would therefore have to object to it being set aside at this time, because I do not believe that it is a true first offense. I think that while it may have been charged as a first offense because the 2007 case would have been outside of the 7-year requirement from the 1997 case, it is technically a second and should therefore not qualify under the statute. I have a copy of the complaint from the 2018 case if the court wants to review that.
Okay, I have the 2018 case you're talking about is the third offense.
Yes, Your Honor. That's sort of what prompted me to go looking a little bit more into it.
And I see that on some of the information we have. Then I see ours from 2007. Correct. Okay. Ma'am. Anything you want to say?
Judge, yes. That was when I was a little younger, was going through dumb stuff, didn't know no better. I've grown up now. I'm doing better. I work at the U of M. I'm trying to stay on the right path, do what I have to do. I have grandchildren and stuff, and I'm just trying to improve my life so that I can do better for my grandchildren.
And ma'am, I am very much supportive of that notion, except that I don't think I'm permitted by statute to set this aside.
Okay.
All right.
When I got those other 2 DUIs, I had lost my sister, and that just caused me to drink my last DUI I had, because before then I didn't, like she said, I didn't have another one until 2007.
Gotcha. No, and I understand all of that, but what Ms. Feltus has indicated is that she, in looking at everything, this conviction is really not eligible for me to set aside in any event. And she's correct. So regrettably, I'll have to deny your petition to set this one aside.
Okay.
Okay. If you think that there's some error in that regard, certainly contact the public defender's office. They'll be happy to kind of look at it and go through it with you.
Do you know about when you think I'll be eligible to do it, if ever?
I can't give you advice in that regard. The statutes are constantly changing in respect to what can be set aside and who can set it aside. But I'd suggest contact the public defender's office, and they'll be able to kind of let you know and guide you through it.
Okay.
Okay. All right.
Thank you. Have a good day.
You do the same. Court does call the cases of the people versus Brook Haybe.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Haybe. Ms. Haybe, can you state your name for the record, please?
Yes, Brook Haybe.
Haybe. We're putting too much emphasis on it.
It's okay, you were close.
Your Honor, we are here for expungements on two separate cases. We do believe that Ms. Haybe is statutorily eligible for expungement, and we did receive a letter from the Attorney General stating the same. And I do have some words on behalf of Ms. Haybe when the court is ready.
I'm ready. Go ahead.
I don't know if the court got her letter and her letters in support, but she did write a pretty lovely letter that I was able to review while prepping for this hearing. And I won't read the whole thing, but I do want to summarize some of the things that she wrote about. She talks a lot about how different her life has been since these incidents and now. Since then, she has become sober. She says that she fully embraced the principles of Alcoholics Anonymous as a guiding force in her life. She's an active participant in weekly meetings, working the 12 steps, and maintaining contact with her sponsor, as well as developing relationships with other people in recovery. She has brought this mentality into her work as well. For 6 years, she's worked in Lenawee County in substance use prevention. She works as a prevention specialist and works with high school, or well, I guess K through 12 students, helping them build tools to avoid falling down that path. She also serves as a coalition coordinator in Lenawee County. She has introduced Narcan to first responders in the community. She works with the Lenawee County Sheriff's Office and the hospital there on their Take Back initiative. It goes on. She chairs Hunger Free Lenawee, which is an organization dedicated to fighting hunger in Lenawee County. So she has brought these values into her everyday life outside of only her, her home. She further writes that since these incidents and since these changes, the best part about the change has been repairing her relationship with her daughter and moving past her addiction. She would like these expunged to improve jobs and things like that. She writes that she had, because of these, had issues with being denied housing or employment. She wants to expand her work of prevention education, reach more youth in schools, and grow further in her field.
So in other words, she doesn't do much during the day.
No, I think she's got a quite open schedule.
Just kind of lays around all day and does nothing, doesn't help anybody. I got you. I get the picture. All right. Ma'am, is there anything you want to tell the court?
No, thank you for that synopsis of my life. Yeah, no, I really am, I do not regret the past or wish to shut the door on it. And also, I just want to kind of move forward from this. It has been a long and wonderful 10 years. There's been substantial growth in who I was to who I am today. And just having this opportunity to kind of clear my record would do a lot for me. And I also think that it would do a lot for my community as well. I'm very active in the recovery community here in Lenawee, as well as Washtenaw, and having this expungement would allow me to do more and reach more people.
Just as I was listening to what Ms. Perrine was saying, I meet a lot of impressive people who, when I first met them, that probably wouldn't have been the first thing that came to my mind. But just listening to what you do, how you sort of changed things for yourself and made something positive. Quite frankly, I don't think it really doesn't matter what I do here today, because I think what is ingrained in you and what you've been doing wasn't solely to get to this. It's about who you are. Mm-hmm. And so I guess what I was gonna say is it really doesn't matter what I do. You're gonna continue doing the good things that you're doing. The other thing that for me, that's of note is, as Miss Perrine was talking, she said one of the things that's most important is repairing your relationship with your daughter. How old's your daughter?
She will be 18 in September. She was just accepted to U of M and we are moving her in. So she
U
will
of M,
be,
that's, hold on, you have to realize something. That's like a Wolverine thing, right?
it is, yeah. Yeah.
Okay, so you have to understand that you're talking to a judge that U of M for me is University of Maryland.
Oh.
So if you're telling me you're going to that blue and gold place, okay, well, whatever. Okay, second rate, it doesn't matter. No, go ahead. I'm sorry.
Well, we're pretty proud of her.
No, and you should be. That is fantastic. A lot of people always they look at the young person and they congratulate them. I always look at the parents and I congratulate them because it takes a lot to get them there. Be nice if it's an easy road, but it's not quite that all the time.
No, my work that I have done personally directly affected Ari in her ability to thrive and have the support and the protective factors that she needed to be the person that she is today. And so I'm incredibly proud of her, and I'm incredibly proud that I was able to be a part of that.
Huh. That's a lot of good things I hear. That's one of the greatest things. But something tells me, I don't know your daughter, but something tells me in a lot of ways, probably that apple doesn't fall far from mama's tree. So I think a lot of what you are was instilled in her. So, all right, that's fantastic. So, ma'am, the court does believe that the circumstances and behavior of the applicant from the applicant's convictions to the filing of the application do warrant setting aside the convictions. And the court further believes that it is consistent with justice and the public welfare. And so for those reasons, the court will grant both of these petitions to set aside the convictions. And ma'am, I have signed your orders. Congratulations. All right.
Thank you.
Have you moved your daughter in already?
Yes, she moved into her apartment, yeah.
And that was hard, wasn't it?
She still has to come back once a month or less, or else she'll lose her room.
Okay, all right. Good enough. No, that works. Okay. I like that. All righty, ma'am. You take care of yourself. Be safe out there. And although, like I said, your daughter doesn't know me, if you get a chance, wish her the best from this judge. I think she'll do well. All right.
Thank you.
All right. Take care of yourself.
Thanks.
Court calls the case of People versus Jimmy Lee Mack.
Actually, calls for the people.
Good morning, Assistant Public Defender, or afternoon. Lauren Perrine on behalf of Mr. Mack. Your Honor, the public is attorney of record on the underlying case. However, we did not assist Mr. Mack in filing the expungement, so I have no information regarding his petition.
All right. Go ahead, sir.
Jimmy Mack Jr. for the record. I do have, if the record doesn't reflect the letter from the Attorney General, I do have a copy of it.
I have it, sir.
Persistence is key, Your Honor. Persistence. I wanted the record to reflect things, so that's why when I was before you at first, my criminal history wasn't updated with the AG office and everything went through. So that's why, yeah.
I remember.
And Your Honor, the most recent letter I have from the Attorney General is March 17th. Is that what the court has?
Let me see.
Date on the letter is February the 18th.
June 26th, I turned in the copy to the.
From the Attorney General, I have a June 26th, 2025.
Okay. I didn't get that, but I'm sure. Can I make a copy of this? I didn't get that, but I'll give it.
Okay. Okay, go ahead.
Well, Your Honor, basically, I'm here before you again, basically, uh, just trying to get my life in order, as you heard before in the other proceedings, and expand my outreach in the community, and better myself and others in the community. And pretty much, my record is even cleaner than what the court has as of now, because I done had some other things that was updated on my record. So even though it does say I'm already eligible, but I'm extra eligible now because
Extra eligible?
Extra.
Extra. All right, go ahead. All right. Well, I've looked over everything and yes, persistence, sometimes you just have to have it, right?
Yes, sir. Yes, sir. Gotta persevere.
All right. The court does believe that the circumstances and behavior of the applicant from the date of the applicant's conviction to the filing of this application do warrant setting aside the conviction and is consistent with justice and the public welfare. Therefore, sir, I will this time around grant your petition to set aside the charge, and I have signed that. All right.
Thank you.
Court does call the case. The people versus Andrew Peggs.
Ashley Phelps for the people.
Good morning. I'm sorry. Good afternoon, Your Honor. Evan Ford, P 80829, on behalf of Andrew Peggs. Mr. Peggs, please state your name for the record.
Andrew Peggs.
This is Mr. Silver.
Oh, no wonder I didn't have.
Okay.
I apologize, Your Honor. I'll withdraw that.
Okay. All right. Go ahead, Counsel.
So, Your Honor, we are here on the motion to set aside a conviction from 2000. This is Mr. Peggs' first operating while intoxicated. We have received responses from the Michigan State Police as well as the Attorney General's office. Mr. Peggs has not been convicted of more than 3 felonies. He does not have any pending criminal charges, and he is not on probation or parole. Following this conviction, Mr. Peggs was ordered to attend a weekend alcohol retreat. He also completed a 6-month inpatient retreat at Dawn Farms in Ypsilanti and was an active member of AA for 4 years. These programs helped Mr. Peggs to realize he did not have a sense of self, which resulted in him creating a life surrounded by alcohol. He now has developed a different personality and better coping mechanisms outside of alcohol. Mr. Peggs spent some time living in Utah following his conviction, and while there, he spent 8 years working as a counselor at Second Nature Wilderness Program. During that time, he worked with youth dealing with drug addiction and dependence. He is currently employed as a platform architect with Rocket Clothes and holds several CompTIA certifications. Mr. Peggs is engaged and a father of 2 boys, ages 13 and 8. He gives back to the community in various ways, including donating blood and volunteering with Gleaners Food Bank and the DPS Distribution Center. Mr. Peggs has worked hard to overcome his alcohol addiction and is not the same person he was 20 years ago. His hope is that this expungement, or by expunging his record, it will help to improve his life in various ways, including with his license and insurance. So given these factors, we do believe it would be in the best interest of public welfare to grant this expungement, and we ask your honor to grant the motion to set aside the conviction.
And Mr. Pegg, anything you'd like to tell the court?
I mean, listening to everybody else, there's a lot of similarities. I would just like to say I'm really, it's a blessing that nobody got hurt when I was making all of those bad decisions almost, 25 years ago now. Other than that, I don't have any regrets. Those decisions are what made me who I am today. I'm a proud father, and my hope is that, I have no plan of keeping my past away from my kid. I think that there's a lot of lessons there, and I think that this is expungement could set an example for him as well. That even though people can make mistakes, they can learn from those mistakes and do better and be better.
You can actually learn from your mistakes.
I've even gotten to the point of learning from some other people's mistakes, but that's a bit fewer and farther between than my own.
I don't think any of us as human beings would be able to move at all if we didn't learn from mistakes, right? Because I've yet to meet perfect human being walking this planet that hasn't made a mistake. So how'd you like Utah?
I loved Salt Lake City. I was skiing. Yeah, it's a great city. Just the inversion smog was not great.
No, right. But it actually, what I like about it is the area out there is beautiful. So that's what I love about it. All right. Having listened to counsel and the petitioner, Mr. Pegg, and an opportunity having given for the Attorney General and prosecuting official to contest this application and hearing none, court does believe that the circumstances and behavior of the applicant from the date of the applicant's convictions to the filing of this application do warrant setting aside the convictions, and also believes that it is consistent with justice and the public welfare to do so. And so therefore, sir, I will grant your petition and your conviction is set aside. All right. You take care of yourself.
Thank you, Your Honor.
Thank you, counsel. Take care.
You as well.
Court calls case People versus Spencer Fry.
Ashley Feltus for the people.
Ain't gonna work.
Mr. Fry is in Zoom.
Yes, Mr. Fry. Who is this counsel?
I just unmuted it.
All right. Sir, do you know where your attorney is?
Let me see now. I think he was running a little behind schedule. He was in a court proceeding. I think he'll be, let me look now. He said he's wrapping it up. He'll need about 5 to 10 minutes. Before you can sign on.
All right, sir, what I'm going to do is I'm going to stand in recess. We'll leave it up and see if we can get to you. I've got a preliminary exam starting, so that could be part of my problem getting you in, but we'll figure out a way to get you in. It may be a bit. All right?
Okay.
Thank you.
All right, cool.
Court stands in recess.
Teenage District Court for County of Washington State of Michigan is now back in session. The honorable Judge Jason.
You may be seated. That's tomorrow.
Yeah.
My client's on the way.
Court does call the case People versus Spencer Fry.
Ashley Feltus for the people.
Good afternoon, Your Honor. I'm Aaron Borey on behalf of Mr. Fry. I apologize for my tardiness. Sorry about that.
All right, go ahead.
Your Honor, this is the date and time set for.
Hang on real quick, counsel. Mr. Fry, are you present?
Yes.
You need a camera, please.
Hold on.
All right, thank you. All right, go ahead, counsel.
Thank you. Your Honor, again, this is application to set aside conviction for a 2004 retail fraud in the 3rd degree. Mr. Fry does not have any pending charges at this time. Per the response from the Attorney General and based on the MSP response, he is statutorily eligible. Again, this is a misdemeanor, so none of the felony restrictions would apply in this case. Over 20 years has passed. He started several businesses, considers himself financially independent. He is very close with his family now, and he also has a very close relationship with God. Your Honor, I believe that the statute does allow for and is supported by the Attorney General's response that he is eligible, and we're asking that the matter be set aside.
Fry, anything you want to tell the court?
I caught this case, quite some time ago, pretty much a lifetime ago, and I'm the polar opposite. Financially stable, don't do any drugs at all, don't even drink. Very close to my family, which I see once a week, and go to Mount Olive Church of God in Christ in Ypsilanti, and just, looking in the right direction, and just want to put this behind me.
What are you doing with your life now?
I've been
You're not doing
self-employed.
this. What are you doing? What? Go ahead.
I'm living a good life, travel, and I'm self-employed, so I kind of got an open schedule. So just pretty much buying distressed properties and flipping them for a profit, mostly like in the Detroit area, Pontiac, a little bit in Ypsilanti, but not a lot. But I currently reside in Novi, and this is just an old petty case, and just wanted to put it behind me.
Very good.
Your Honor, I told him to.
Oh, go ahead.
Your Honor, I told him to dress up, and I think he's got a tuxedo on.
Yeah, I was like, well, I'll be honest with you. When he first appeared on the screen, I thought, oh, so he's going to have an expungement and a wedding all on the same day.
I'm the attorney now.
Is that what?
Oh, right.
All right. The court, having heard the argument of the petitioner and an opportunity have been given for the Attorney General and prosecuting official to contest this application, and having heard none, the circumstances and behavior of the applicant for the date of the applicant's convictions to the filing of this application do warrant setting aside the conviction in this case, and the court does believe and would find that it is consistent with justice and the public welfare. Therefore, the petition to set aside is granted, and I have signed that order. Congratulations, young man.
All right. Thanks a lot. Appreciate it.
Thank you.
All right.
Have a nice day.
All right. You do the same, counsel. Court does call the case of the People versus Jillian and Kerry.
Good afternoon, Your Honor. Shalani Feltus for the people.
Good afternoon, Your Honor. Michael Bellato, on behalf of Ms. Kerry, who's present.
All right. Thank you. All right. This is date and time set for the continuation of a preliminary examination. Are we ready to proceed?
People are ready.
All right. I believe it was the cross-examination of Detective Parker.
That's correct, Your Honor. May he have his water up there with him?
Yes.
No objection, Your Honor.
So if I could have him re-sworn, yes.
Take a seat, raise your right hand. You solemnly swear to affirm the testimony you're about to give the truth, the whole truth, so state, spell your first and last name for the record.
Parvis, last name spelling is P-A-R-V-I-C.
All right. You may now exercise your client's constitutional right to cross-examination. Counsel, you may proceed.
Thank you. I appreciate that, Your Honor. Good afternoon, Detective Parvis.
Good afternoon.
You have been a police officer for the past 25 years, is that correct? Okay, and just so that I understand your journey, did you start off with the Detroit Police Department, DPD? Is that yes?
Yes, I did.
Okay, what year was that? Do you recall? I'm not trying to date you, by the way, just trying to. Okay, and then what did you do at DPD? Like, what were you, a patrol officer? Did you deal with any electronics or computer forensics or anything like that? I'm sorry, having a hard time hearing his answers. If you could.
The answer is no. Sorry about that.
Yeah, I don't have great hearing. I appreciate it if you would speak up. And so at some point you left DPD and you went where? To the Washtenaw County Sheriff's Department? And when was that?
February of 2000. That's it. February 2000.
And was it there where you started getting more involved with forensics
Slowly, yes.
in criminal cases?
That's correct.
And I noticed that I think you have a graduate degree, do you not, in forensic, digital forensics?
Yes, my master's degree is in digital forensics.
Oh, thank you. And then I remember when you were testifying, Detective, you talked about, I think 70. You said, I've gone to 70 trainings and I lost track because you've been going to so many trainings. Is that right?
Yes, as far as the training certifications and all that, over 70, well over 70.
Okay. And then when you go to these trainings, you called it a certification. Do you get like a piece of paper saying that you went to the training?
Some offer certifications, some don't, but I have kept track of the dates.
Oh, thank you. And specifically, have you had did any of these training certifications involve specifically Microsoft Exchange server forensics?
No, that's training.
No. What have you done to get up to speed on Microsoft Exchange server?
I have academic background in Microsoft Exchange.
Okay, what is the academic background?
It was both in bachelor's degree and in my PhD program had some.
Okay. What year was that?
Bachelor's degree was in 2007 and sometime around then. I'm just giving you a ballpark estimate. My PhD ended in 2022. Sometimes.
I'm sorry, you have a PhD in forensic in digital forensic?
Information assurance, which is basically a combination of network security and computer science.
Thank you. Since studying about Microsoft Exchange Server, as I think you said part of your PhD, was that in 2022?
And in August of 2022, I think.
Okay. Have you done anything since August of 2022 to sort of keep up with Microsoft Exchange Server forensics?
Yes, I did some postdoc research through Sands University. I took the 400 level class just to refresh some memories and to do some research specifically in research. And I completed servers. There were servers.
Okay, when was this post-document research? Do you recall?
2023, not too long.
Okay, thank you. And you are familiar with the Scioto Township email system. Did you become familiar with it during the course of this investigation? Maybe I'll ask you that way.
That's a very broad question. No, I don't know their whole system. I would say that I can apply what I know to what I have received from Scioto Township.
Understood. Do you know whether Scioto Township used an on-premises server or a cloud-based server, if you know?
I believe that they use a GFI on-premise server that has a connector to Microsoft Exchange.
Are you talking about the GFI archiver? Is that the same thing? Because
that's correct. That's a server that's an archiver of
does that mean that the server is physically there at Scioto Township?
Well, I don't know if it's actually physically in that brick and mortar location. It could be in an adjacent place. I don't know.
But
at some point, I tried to make contact in person to see their server. I wasn't. It really doesn't matter. They do have an in-house. Call it an in-house.
Okay. You just don't know exactly where it's physically located, correct? Fair to say?
Big idea.
Oh, what is your big idea?
So at one point, when I went to, for the first time I ever went in person, to talk to Mr. Hathaway, he he took me to the back where, their IT person was. And the door was closed and there was a sign that he was in a Zoom meeting or something. And I'm guessing that was the server.
Oh, understood. And that person that you were trying to see, is that Chris Bailey, the former IT director?
No, he was gone then.
Oh.
It was a,
Was it Julio Barros? Is that possible?
yeah, that's it.
Okay, Mr. Barros, thank you. So in your understanding, Scioto Township did not use a cloud-based server for their emails, correct? A cloud-based server.
Well, yeah, they do. I mean, so you can have a local server and there's what's called a connector. It's an add-on that you actually are using, but there's a stop on the way. That's the best way I can.
So it's, in other words, you could use both. You could have a server that's a physical server, but also use a cloud server? Or am I saying it wrong?
You can do that. You can archive your emails locally and the server is going to keep your information.
Understood. How many, would you say, computer crime cases have you personally investigated that were assigned to you, if you recall?
I actually have a documented list of all my cases, and I believe I'm at around 600, maybe 70.
Okay.
And that entails over about 2,700 devices that I've investigated that I can apply.
And what types of crimes did you investigate with these 670 cases? Let me just ask you, were some of those maybe child pornography cases?
It used to, when I started, there was a lot of those involved. And then as cell phones and computers became bigger, people started using many of them. So I'm involved in pretty much any case that comes around.
Were you ever involved in a case where you had to make a determination, besides this case, any other case, these 670 cases, where you had to make a determination as to whether or not an email was sent manually by a user versus by Microsoft Outlook's cached mode synchronization process?
This is a very specific case. I have never had one that was, but no two cases are identical. If you wanted to ask if I've ever done any server crime, server related cases, yes, but not this specific one. Other two cases are identical.
Yeah, well, let me rephrase the question, because I'm not asking you if this case is identical to any others. I'm asking you if you were involved in a case where it was your duty in that case to distinguish between an email that was sent manually by a user versus sent automatically by Microsoft Outlook's cache mode synchronization process.
Again, this is a very specific case, that the one that we're here today, and I've never had anything like this.
Okay, thank you. And I see from your CV that you've testified as an expert in state court, correct? Have you ever been testified in federal court?
I testified in a grand jury case once. The rest of most of my cases I go through the federal system are pedophilia related, and they plead out. Yeah.
And when you testified as an expert, did you always testify on behalf of prosecution?
I testified once on the behalf of the prosecution, but the prosecution was wrong, and I actually my testimony was on the side.
I'm not asking that actually. Let me try to rephrase it. Maybe I said it incorrectly. I'm asking, have you ever been a witness testifying on behalf of the defense?
On behalf of the defense, never.
So you've always been a witness that was called when you're an expert by the prosecutor, correct?
It was called by the prosecutor.
In every case, correct? In every case.
In every case, I was called by.
Thank you. And did you ever testify about this issue of whether an email was sent manually versus automatically transmitted?
As I said, this is a very.
Have you ever published any peer-reviewed articles on email forensic analysis? All right, let me take you back in time a little ways, back to November the 19th of 2023. And you understand that the charges in this case relate to an event on November the 15th of 2023, correct?
Correct.
I'm asking you about 4 days later, on November 19th of 2023, were you given a summary of the case by a deputy sheriff named Alex Phillips?
Yes.
And do you know the date of, would it refresh your recollection to look at a copy of Deputy Phillips' report to tell the date that he gave you that summary?
I mean, if the date matters, I believe you.
Yeah, I'd like to get the date, if you don't mind. May I approach to refresh, Your Honor?
You may.
I'm just going to show this.
What's it, the original? Yeah, that's it.
You just read that paragraph that I showed you to yourself and let me know when you've done it.
Just read it to myself?
Yeah, just read it to yourself. This is a, yeah.
Yeah, I do.
Okay, thank you. And can you tell what date that was? Did that refresh your memory as to?
I didn't look at the date.
Oh, can I approach again? May I approach? Sorry.
The next. Yes.
So then on November the 19th, that's when you first got wind of this case, correct? And Deputy Phillips gave you a short summary of what he knew?
Yeah, this is very normal, especially with deputies that are brand new. They don't know specific laws regarding cybercrime. So they approach me, they say, okay, this or that. Is this something that I should follow up? Is there a crime that's the is there a crime committed? And I give them based on their summary, and I go, okay, so here there's the statute.
My question to you is did you tell Deputy Phillips on November 19th, 2023, that criminal actions had been taken in this case?
Yeah, based on what he was telling me, that was something that I heard.
But you had not received any digital forensic evidence at that point, correct?
No, what you told me was.
I'm sorry, I just really want, I'm not asking what he told you. I'm just asking if you received forensic evidence before you made that declaration.
No, I had not received anything.
Thank you. But from the summary, you knew that the issue was going to be in the case, how, or what you had to look into was how this email, and I'm going to be talking about the election email, and I'm talking about the email that went out at 6:08 and 37 seconds from William Hathaway's Outlook account. You know what I'm talking about? When I say election email, do you know what I'm talking about?
Yes, we can refer to it as the election email from now on.
Great, okay, that's what I'll do. But was the main thrust of what you were going to be investigating, how this election email got transmitted on November 15th of 2023?
Pretty much.
And you knew at the time that both Mr. Hathaway and Ms. Kerry denied sending that, correct? Or did you?
On the 19th or what?
Well, at some point you learned.
At some point, I understood that was.
So both are denying it and you're trying to find out how it got sent, correct?
That's correct.
All right. Let's talk about the 15th first. November 15th, 2023 at 6:08 p.m. And you can refer to your report at any point if you want to. I'm not trying to catch you off guard here. But 2 items went out from William Hathaway's Scioto Township Outlook email account, correct?
That's not correct.
All right, well, I'm going to ask you about 2 items. I want to ask you about these 2 items. Did these 2 items go out at 6:08? Well, hold on. You said it's not correct. I'm not going to talk about the seconds yet, but.
I'm sorry, I'm gonna object to the form of the question at this point. I think it's very.
Okay, it was confusing and I'll try better. Two items went out within 27 seconds of each other on November 15th, 2023. One went out at 6:08 and 10 seconds. And I'm talking about a Zoom invitation. Do you recall that?
So you're saying two items went out. We know that one item went out based on the server log.
Okay. So are you taking issue with there being two items going sent from Mr. Hathaway's email account at 6:08 and a number of seconds?
The first item you're referring to, we don't know if it went out to his email.
And all right, so you're saying that the Francis Zuma meeting invitation from Zoom did not come from Mr. Hathaway's email account?
It may not have been. I don't have any evidence showing that. As a matter of fact, the only evidence that I have shows that it was sent through the calendar, which means that it could have been sent through Zoom, not through the email. And that would explain why the server is not showing that item.
But you know that item was, well, I'll get to that later. All right, well, I'm going to ask you about both of these two items. I'm going to be asking you about what I'm going to call the Zoom invitation, which is what you just described to Francis Zuma. You know that Francis Zuma received the Zoom invitation at 6:08 and 10 seconds, correct?
Yeah, that doesn't mean that it was sent.
Yeah, I'm sorry. I'm just asking if you know she received it.
I don't know. I don't know who this person is.
Did you review the email header or the calendar invitation?
Is there the email cat?
The email header?
Email header for the.
Yeah. Yeah, would it refresh your recollection to look at a copy of it? Yeah, approach.
For the record, I don't recall what the.
This is something I'm going to ask.
Wait, no, I know, I'm just saying, I don't know if he's seen it before. I'm just trying to remember when that came. Do you remember when you got that?
This is from a FOIA request.
But we're not necessarily in possession of it.
I'm not introducing it. I'm just.
My question was, you asked him if he recalls, I'm asking how has he seen it? Is he, has he seen it? But how can it? But you asked him if he's seen it before.
Well,
I'm just trying, I just want to know when it came up. That's all I'm asking.
I'm trying to show the witness something that may refresh his recollection. If he hasn't seen it before, he can say so and say it hasn't refreshed his recollection. I'm representing to the court that it's an email header for the Zoom invitation.
And Your Honor, my only question for defense counsel was just how that had come over before, just because I think the question was about if this witness had reviewed something and he couldn't recall. And so I don't, there's a lot of documents in this case. I don't recognize this one off the bat. So I'm just trying to figure out where it is. So I know if this is something that has been reviewed or not. I'm not trying to slow down the cross. I just want to understand where this came from.
Where did it come from?
It's from a FOIA request. We got it from the
township.
Yeah, Your Honor, I'm not trying to introduce it. I just wanted to refresh his memory.
Well,
if I could.
I don't know how it. If you receive something through a FOIA request, who knows whether or not he's seen it?
And it may have been given to us when he did an additional report. I'm just trying to locate it, Your Honor, so I can understand.
You know where it is in that? When are you talking about when defense counsel gave you an additional report? Or
I'm talking about when Mr. Childers and Mr. Bellata met with Detective Harbes with additional information, and Detective Harbes prepared the additional report. I think the court recalls we've had several reports here. One of them happening after that meeting. I'm not sure if this is something that was given to defense departments at that time. I just don't recognize it. That's why I was asking, not trying to jam this. So I'm just not quite sure where this came from. So I'm not clear if this was ever given to my office before. But if the defense counsel is attempting to use this to refresh the witness's recollection, and it doesn't refresh his recollection, I guess we'll go from there.
Thank you. Just take a look at that yourself, and then I'll ask you if it refreshes your memory.
I've not seen this before.
Okay.
That's the question.
All right, thank you. So then it doesn't refresh it. Okay, thank you. So you don't know, as you sit here on the stand right now, you don't know what time. Well, do you even know what date the Zoom invitation to Frank Zuma was received by Frances Zuma? Do you know what date she received it?
I'm guessing you're going to say on the 15th.
Well, didn't you write reports about that?
I don't think I mentioned anything about Zuma. What I mentioned was I'm bound by the four corners of my monitor. I'm digesting the front.
Okay. Do you have any evidence to refute that she received that email on November the 15th, 2023? Or that's inconsistent with that, I guess?
I know that it's, I'm going to call it the email.
Let's call it a Zoom invite.
Yep. I know that it was sent on the 15th automatically. And I believe your previous examiner also agreed.
Right. And you read the report of Mr. Lawrence Lieb, correct?
Oh, yes.
Yes. And he discussed that calendar and Zoom invitation.
I agree with it that it was sent automatically on the 15th.
Did you agree with him that it was sent at 6:08 and 10 seconds?
Yeah, I believe so. It's,
okay. All right.
Yes, that's correct.
All right. Thank you. So you agree that the Zoom invitation was sent at 6:08 and 10 seconds, correct?
Yes.
Okay. That's what I was trying to get. Thank you. And then 27 seconds after that, email forward of an email from July of 2022 was sent out from Mr. Hathaway's email, correct?
They're not the same footings, but just for the record, these are completely different.
Right.
But
you could, okay.
The second one is an email that was sent. Yes, that's correct.
But I'm focusing on the time right now. Okay, you already said that the Zoom invitation was sent out at 6:08 and 10 seconds. I'm asking you, was the election email sent out from Mr. Hathaway's Outlook account at 6:08 and 37 seconds? That's what I'm asking. Yes?
Yes.
And you understand that Jillian Kerry is not disputing the fact that she was operating the shared laptop at that time when both those things went out. You understand she's not refuting that, right? She's not. Okay. The question is, isn't it, how did that email get sent? Okay. And you understand that the defense and Mr. Lieb maintain that it was done automatically through Microsoft Exchange's cache mode synchronization, correct? That was Mr. Lieb's.
Yes, but it makes sense at all.
Okay, I understand you don't agree with it. I'm just asking, is that what he was in his report, correct?
Objection, Your Honor. I think that he's answered the questions.
Sustain that objection.
But you, all right, I'll move on. And you know from the investigation, I mean, you did other things, by the way, didn't you? Besides just look at raw data, you talked to people like Will Hathaway, didn't you?
I went in person and talked to Mr. Hathaway once. And then, yeah, that's crazy.
Yeah, and sometimes would you agree that when you're trying to make a forensic determination, sometimes it's important to know other facts surrounding the digital forensic item that you're reviewing, correct? And one of the things that you learned through the course of this investigation, that around the time that the election email got sent, Jillian Kerry was trying to start a meeting in the township hall, correct? And are you aware that she has a email account called racchair@sciotownship.org? Okay, but are you aware that she was she had received a Zoom notification code at 6:06 and 45 seconds to that email?
Makes sense.
Okay, but you do know she contacted Zoom on the shared laptop before she launched Outlook, correct?
But based on forensic findings, I believe Zoom was initiated before that email was opened and sent.
And you know you've used Zoom before, haven't you? And you know that sometimes when you try to use your Zoom may send what's called a authentication code to your email, correct? Well, if you don't know that, just say you don't know. You don't know? Oh, I can't testify. You don't know, you just say you don't know. You don't know, okay. But you don't have you didn't see any forensic evidence to call that into dispute that you received an authentication code. You don't have anything to the contrary, correct?
I don't know one way or
another. Okay, thank you. Now, in the course of your reaching an opinion in this case, in addition to Mr. Lieb's report, did you also review a report from a company called N1 Discovery? And is it your understanding that this report was commissioned by the township?
I don't think so.
And I'm going to ask you about a couple parts of this report. And if you need to refresh your memory, I have it right here. But I want to ask you if you agree, and I'm going to be reading from the report just because I want to understand if you agree with this. Do you have a copy in front of me?
I do.
Oh, perfect. Can you go to page 2? Yep, the second to last, sorry. Yeah, second to last paragraph. Oh, sorry, the very last paragraph. I apologize. The last paragraph.
The one that starts with since.
Yeah, the one that starts with sin. So I'll read it, and I'm going to ask you if you agree with it. Since there were no sign-in events, but artifacts show the Outlook desktop application syncing the Hathaway email account, this indicates that the Hathaway email account had been previously signed in to the shared Dell laptop, and the profile was still present and active. Do you see that sentence?
Yes, and yeah, it's called an SSO, single sign-on. That's when you have when you log in, you actually sign in also to other applications. That's what they're referring to.
Do you agree with that sentence?
Yeah.
That finding?
Well, since there were no sign-in events, but artifacts show the Outlook desktop application syncing the Hathaway email account. The Hathaway email account has signed into share. Yeah, I can't speak that. That's right.
Okay, that's correct. Thank you. And then the last sentence, the very last sentence, states that Microsoft persistent features would have kept the account signed in. Do you see that?
Yeah, that's the essence of
Okay. And then, so you don't have any reason to doubt that when Jillian Kerry logged onto that, or sorry, when Jillian Kerry launched Outlook on November 15th, 2023, Mr. Hathaway's email would open automatically into his email. So this isn't you're not investigating a hacking case where someone steals a password and signed into somebody's email account, are you? That's not what happened here. You agree with that, right? What happened here is Mr. Hathaway's email opened when Ms. Kerry clicked on to launch the Outlook. His automatically opened because of this persistence that you just mentioned, correct? Is that yes?
Yes.
Sorry, you have to say yes or no. You can't say yeah.
Yes, it was so obvious that I said yeah, but yes.
Thank you. And the icon on the shared laptop, you would expect it to be just a generic Outlook icon, correct? Okay. Well, let me rephrase it. Do you have any reason to believe that Jillian Kerry would have known when she clicked on the Outlook or she launched the Outlook that it was going to open to William Hathaway's directly into his?
I don't know if she had the past experience with that laptop ever. I mean, I don't know if she's ever used it to log into Zoom and that had happened before. I don't know.
Well, I'm asking you specifically, since this is a criminal case, if you have any evidence that she knew that his account would open.
Objection, Your Honor. I don't know how he can know what's in the defendant's mind.
I'm asking that corroborating evidence, Your Honor.
Well, he answered the question once and said he didn't know what she knew. And then the question was rephrased, and it's essentially the same thing. So now it's also has an answer.
I'm going to sustain.